Hello, everyone, and welcome to a very special live stream tonight. We're still geared towards true crime, as always, but tonight we're going to talk about something that affects all of us as YouTube creators, subscribers, and the like. So, welcome, Wilby. It's good to have you up on panel again. It's been good to
Hello.
see
How
you.
is my sound? I just checked my sound. Is it good here? I just want to make sure before we get started. Real.
Yeah, you sound
Okay.
great. Do
I
I
thought it
sound
would.
okay?
I thought everything checked on Almanian. Yeah, it's been crazy. Uh,
It has. It has. It's been. I've been busy. I don't know about you, but it's been hot out, and I've been busy on top of everything else.
yeah,
Back
we've
and
been
forth to
lucky. We've
court.
had some breaking weather. It was like it's literally almost cool out at night. It's not cool, but it's just very comfortable. And today, I think high today was low 80s. We've had perfect weather, but we've got some more hot weather coming. Though.
Yeah. Well, it's a cool off here now. So I
Yeah.
think today was 80 degrees was the high. It was
Oh,
so
it was
nice.
just absolutely gorgeous the last few days. You get break a sweat if you get out and work a little bit, but at night with the window cracked, if you wanted to, you felt. I mean, it was nice.
Yep. So, Wilby, have you been following everything going on? The lawsuit that
I have.
started.
I listened a little bit today on Granny's as she was reading the suit, and I couldn't decide whether he was being serious and he really wants to sue this girl, or he's just bothering the you know what out of her just cause he can.
Well,
I don't know. I couldn't figure it out.
right? It doesn't make any sense to me. It's like they have targeted. Listen, they have targeted this poor woman for doing nothing more than trying to actually be unbiased and cover a missing persons case.
And she's the one person that stayed kind of she'll get with other creators like Queen and different ones, but she's kind of kept everybody at arm's length throughout all this.
Right.
She'll do a little something with them, but then she eases back. She stays in her own lane, and
Yes.
I
And
don't get it. I couldn't like today. I was like, I just don't get this, and I don't know why. It just don't seem like he's just bothering her just because he can. I don't know.
yeah, I mean it's ridiculous. First of all, you got, let's see, 10 people, right? You got Nick the Hat, Hong, uh that Julie K9 girl,
Yeah.
um Bullhorn Betty, uh Seth, uh let's see who else.
Uh, I'm trying to think. I think he about got them
Tony
all.
Mathis.
Tony Mathis, the national spokesperson, I might add.
Right.
Uh,
For Sebastian Rogers in a missing persons case.
yeah, but I almost think I wonder if I've been thinking, is there maybe there's enough money if you get lawsuits going and you get your content becomes it kind of weighs out on your side at the end of the day. What you pay a lawyer, you make more in channel revenue. I don't know. I mean, if these people they're suing, they're a losing proposition. I can promise you that. Even if you get a judgment against them actually signing a check and taking their $100 bills and giving them to you is it just don't happen like people think.
Right. Well, not only that, but you got to think every one of these people have inserted themselves as public like limited, oh, what are they called?
Uh,
Limited
uh
public figures.
yeah,
Okay. But they've all inserted themselves as spokespersons and etc. Intelligence agency
that's
working
right.
the case. Oh, Dog the Bounty Hunter. He was another one that signed
Yeah,
on
that's one we
under the
forgot.
original lawsuit. But they've all filed lawsuits, and the original lawsuit in Pennsylvania was against Granny's Watching and
The
Barbecue
barbecue
Lady,
lady.
from
And just
TikTok.
because Granny was picked just because she lived in Pennsylvania, and I think Brittany suggested her just because she hated her and she was jealous of her.
Right. Well, now we
I could be
have,
wrong, but I think that's what it was.
right, but even further than that, after allegedly with Brittany has filed this injunction against Granny to strip her of her very constitutional rights themselves. We've got Brittany threatening more lawsuits. There's a I guess a strike wars going on, um, or starting or something,
I don't
threatening
understand
some
that
strike
either.
wars.
I don't
Right,
understand it either. It serves
right,
no purpose for nobody.
yeah. Connie said, "Wilby, she thinks you're right. She thinks you're right."
I mean, maybe if they spend X amount of money on a lawyer, and maybe the content generated by all that generates X, X plus X times two. I don't know. I could be totally wrong. I mean, but I can think I've been in court more than probably just about 99% of the people in here, it's always a drain on money, and the getting of the outcome you want takes forever. Number one, and you just don't get there
You
all the way
don't.
anyway. It's not very
No, you
satisfying. You thank God when you walk out of it and you're done.
right. Right. Um okay, so I asked Granny's watching. She did a very good live earlier today, her and Nonsense breaking down. So you know that right now the original injunction out of Pennsylvania is on its third attempt at appeals.
Yeah,
Um the original ruling was in favor of the anti-slap was granted for
yes.
Granny's watching and barbecue. And so they appealed it. The appeal was shot down, and then they appealed it again and didn't file um,
In
the
time or something.
in time the documents in time
Yeah,
for their case, essentially their arguments. Um, so it's gone back now. It's going to the Superior Court.
yeah. I
But
think they want to make sure procedurally that it's done right, so that maybe when that lady judge who seems to be ready to make some decisions that some people are not going to like, and I think I don't know. I just think that they're going to want to make an example. They passed this law in that state, and it took a lot of the state. I don't know if they got legislators or state commission. I don't know how they get elected in state government, but they passed it, and they want results from it. And the first case is going to be have a lot to do with it. So I think they want everything to run smooth. They want all the T's crossed, all the I's dotted. So when she says it's slap, I'm going to ordinance to you that there's no appeal after that
right.
can change it.
Well, do you remember? I don't know if you were over there or not, but we were on Trisha Talks and we were talking about this secondary lawsuit that Tony Mathis has filed. It's a frivolous lawsuit, of course, in my opinion. And once again, an attempt to silence Granny, um, doing nothing more than exercising her constitutional rights to report what has already been reported in the public eye. And we're gonna pull up this live stream from Granny today because
Yeah,
this is her lawyer's motion to dismiss, and I thought it was brilliantly written. But she uses some of the things that I had originally talked about, the problems with Tony Mathis filing this lawsuit in Oklahoma to begin with, right?
yeah,
They don't have jurisdiction, in my opinion, which was one of the grounds Granny's lawyer has filed a motion to dismiss on, which was res judicata,
yeah,
judicia, judicata, however you pronounce it.
yeah,
Um, and I think that the her attorney has done a very good job um, writing this motion to dismiss, but also it is so well written that it elaborates on exactly why it should be stricken down. And the thing is, the reason I'm bringing this to everyone's attention is because this kind of lawsuit can affect any one of us YouTube creators. Okay. None of us are above having people with nefarious plans that lose in trying to silence us the first time and trying to silence Granny the first time and us
yeah,
trying to silence them are now going at a second attempt in another state because they're losing the original lawsuit and they know it. Um, and mind you, Wilby, they're doing this all on the back of a missing child, on the back of
yeah.
Sebastian
Uh,
Wainwright
I never
Roberts.
understood any of that. They were trying to act like Granny had, through her actions, stifled the investigation and searches and blah 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 blah. It was basically about the most ridiculous statement I've ever heard in my life. If anybody stifled it, it was their group running around telling people you can't search, you can't search, don't you search, and hollering they're going to search
Absolutely.
every other Wednesday or Thursday, and nobody ever showing up.
Acting like the end all be alls of the case
Yeah,
whenever
oh,
actually they were doing very little. I mean, in the original injunction, Seth said they only searched 4 times,
I've heard that.
right?
They said Seth would keep saying, "I'll be there Thursday," blah blah blah. And he would talk a good game, but come time to be there, he was hard to find.
Right. So, as you know, Tony Mathis, national, and I say that in quotation marks, spokesperson for Seth Rogers, father of Sebastian Rogers, has filed another lawsuit against Granny's Watching in Oklahoma. And the reason this is so important is because this is a never ending cycle. And unless we come together and stand up together for what is right, and in this case, it is freedom of speech, the right to report. Um, unless we come together and stand up against this and actually speak up and say our piece and support Granny in this frivolous lawsuit, then none of us are safe from it. None of us,
Mm.
right?
No, I mean, if they take any little statement you say that it could be opinion or fair use, you're just evaluating something and saying your opinion. I mean, they could pick every creator apart on the platform.
Right.
But
So for educational purposes and because they did such a good job of going over this today, I asked Granny's watching if we could use her stream from earlier and she gave me the go ahead. Um so first of all, I want to put Granny's watching her link in the chat. Um the video and the link to Granny's video is in the description down below. But you guys go over there, give Granny a thumbs up, show her some support because she is fighting honestly for all of us. I mean, honestly, she really is. She's fighting for all of us. Here's the link to her video.
is he strictly suing on defamation?
Yes.
And that you got to prove. It's like 4 or 5 things you got to prove, and it's not. It's not as easy. And well, first of all, you got to prove that she absolutely asserted this. Like Regina is just whatever. I not. I have an opinion, Regina, or that's the first thing. Then there's got to be something false within the statement. Then it's got to damage the person. It's all kind of stuff you got to prove, and it's not easy.
Well, we've got these same people that were so excited to sign on to this free lawsuit that have lost in Pennsylvania that are already trying to go after Granny and other creators now.
Yeah. To this
Um,
day, that first document, I read it. I do not. I will bet every nickel I got that was not written by a trained lawyer.
oh, you and me
It was the
both.
most discombobulated document I've ever read in life. It made absolutely no sense. No more than I know about the law. I know a little more than the average person, but I'm not a lawyer, and I'm never going to be one, and I'll hire one if I go to court. Uh,
Right.
it was a poppycock. It was just ridiculous. It made no sense.
It is. It's absolutely ridiculous. It's garbage. I mean, it's essentially garbage. It's a waste of the
Court
court
time.
system. It's a waste of time. It's a waste of money,
I mean,
effort.
they use
There's
RICO to go after the mob for an organization that acts as an organization and all kind of predicate acts of robbing and stealing and all kind of crimes, and it wraps the whole group of people up. How
right,
that applies in a civil lawsuit against two people that didn't even know each other before this thing started. So how could they have been an organization? It just
right,
none of it made sense to me. I don't
right.
get it to this day.
Well, let's get into it a little bit because I think it is so important to go over this to show everybody the claims that Tony Mathis is making and exactly how unfounded they are. But also keep in mind Tony Mathis is not the only person harassing Granny. There are other content creators, allegedly with Brittany, just a girl who loves frogs. All I mean, just there's the whole group. They're called the Green Team.
Yeah.
They're called the Green Team, but they are stopping at nothing to make poor Granny's life a living nightmare for doing nothing more than reporting on what these people said themselves that they have done themselves and what other people have reported on.
But according to them, they're doing it in response, and Granny is doing it in an attacking and bullying mode.
Right.
They're acting like no. Both sides are going at each other. Let's just be honest. At times, both sides have lashed out at one another, but they're not just responding to others or Granny. They're laying
But
out plenty of their own.
you've got Brittany over there with a GoFundMe to file more frivolous litigation against YouTube creators.
We think.
She said,
Yeah, she
no, this is what
says.
she has said.
Yeah.
As a matter of fact, her not her husband because they aren't married, but her baby's daddy, I guess you call him. Yeah,
Uh,
Craig.
her
Craig, her baby's
landlord.
daddy. Yeah,
Her
her landlord.
landlord.
That too. Um, he has come out and said that he's going to sue YouTube as well.
He's an idiot. Does he realize how big Alphabet Corporation is?
I, I don't know.
I mean, and that's the most ridiculous statement I've ever heard in my life.
Right.
He's going to
Okay.
sue you too. Okay.
So let's get into this really quick. And I've got it pulled up to where Granny starts reading, and we're going to pause throughout and discuss things that are in this lawsuit because let me tell you what will be. The
Yeah.
ridiculousness is astounding.
It,
Like the
it's
stupidity
just,
of
it
this
blows
is
my mind. I can't make sense of it other than it's just stupidity.
right. It's utter stupidity. And the fact that they're targeting one person, y'all, she's a mom. She's got two kids she's raising on
That's
her
right.
own, mind you.
That's
You
right. You
know,
know, and every weekend she gets away and she takes her kids to the beach, to parks, to theme parks, and really she gets out. It's not just YouTube for her 24/7, and I respect that. Uh,
me too. She doesn't live her life on YouTube, but
no,
she
she's
also
got her
doesn't.
kids at the beach or a theme park or a getaway for just maybe if it's just a day. Every weekend, every week, they're not sitting on a live stream waiting for their mother to get done with a live stream to, every second. She gives those kids plenty of things to do.
Right. Right, she does. She's there for her kids.
Yep.
Not only that, but she doesn't comment and go she doesn't go look up people's records and stuff like that, right? She's not doing what they're doing to her and doxing her and stuff. She's simply commenting on what they've said themselves and what's come out in other media. And that's the mind-blowing part of it all is, in my opinion, some of the things that Granny is being accused of defamation for are not even her originating from her, you know what I mean?
Uh, she a lot of times they'll read a statement in chat, and then they'll talk about that, and then it gets twisted around. Granny said this. No, Granny didn't say that. She read what somebody else said, made a comment or two, and added to it, or to try whatever, however she, analyzed it. But I don't know. People get so much stuff twisted, and they run to their creator, run to person. Regina did this, and Granny did that, or this person did that. A lot of creators we know do not check anything, and they just take the ball and run and bounce it without fact checking any of it.
Yeah, but will be the problem is this has gone beyond, little spats on YouTube, between creators not agreeing on something. This has
Yeah,
gone real life.
yeah, it's
This
gotten
has
where people
gone,
want to get one up on somebody, no matter what somebody does. I want to get them that, and then one more up. And
yes.
eye for an eye ends up everybody ends up blind.
Yep, eye for an eye. Everybody ends up blind. That
Yeah,
is
I mean, so
absolutely
at some
correct.
point, everybody's got to be the bigger person. I'm stopped. They got me good. I'm upset about it, but I'm tired of this.
Yeah.
You
I guess, it almost seems like some of the people that are attacking are on a self-destructive mission because there's no winning whenever you look. My rights don't begin, and neither does Granny's where anyone else's begins.
uh, Granny, through her process with Brittany, has made mistakes, but she has recognized them, she has owned them, and she has grown from them.
Yes.
She has a person and as creator, and she'll tell you this. You can listen to her. She tells you plain and simple. And in the beginning, it was amateurish on maybe both their parts. And she moved on. She learned lessons, and she learned them well, and she changed her behavior. She's still not perfect, like none of us are, but she's continuing to understand. I got to learn how to operate in this platform within these rules and these confines and all these creators, and it can't be that complicated as we're all making it. And she's
Right.
doing a good job, I
Well,
think.
and I'll tell you this too. Her lawyer is doing a
Oh yeah.
great job. Um, I know that, he was called a backdoor attorney by the Green Team, but you'll see. Let's hop into it and start listening in because Granny reviewed the motion to dismiss today, and it is amazing. So let's go ahead and hop right into it.
Yes. Lady K9. Sorry, I apologize. I didn't see that sooner. I did see the number going by, but I thought it was thumbs up or something. I didn't think of it.
Commercials. Gotta love the commercial.
All right. So this is what we filed. Through my counsel, Lloyd Brent Palmer of Palmer Law, without waiving personal or subject matter jurisdiction, appears specifically and limited in response to petitioner's pleading. For the reasons stated throughout, should this Delaware County State of Oklahoma case be dismissed or stayed pending the outcome of the Delaware County State of Pennsylvania case appeal, I don't even know what that means. I'm so sick of litigation. Defendants without sufficient information either omit or deny paragraph 1. So that's basically where Tony lives. Defendant concurs that plaintiff Tony Mathis claimed to live in Delaware County, Oklahoma, in an ongoing and active suit filed in Pennsylvania against defendant concerning the same subject matter. See Exhibit A. It must be noted the Pennsylvania complaint makes mention of numerous exhibits. However, the exhibits were never filed with the Pennsylvania complaint and are not part of the record in trial court. It's embarrassing. Because paragraph 1 is an attempt by plaintiffs to establish subject matter and personal jurisdiction, defendant wishes to establish early in her answer that plaintiff is already suing defendant in Pennsylvania over the same subject matter, and the suit in Pennsylvania has not ended. See Exhibit B. Therefore, Pennsylvania has both personal and subject matter jurisdiction over defendant in this matter, not this District Court of Delaware County, Oklahoma. That is because plaintiff Tony Mathis initially chose Pennsylvania as his forum and is still in that forum. Plaintiff Tony Mathis is actively appealing the dismissal of his complaint. That complaint sought inter alia, a protective order to prevent defendant from broadcasting. That request for.
Do you remember that? Do you know what the protective order she's talking about? The same protective order that they accused me and my husband of live streaming somehow from court because my husband was on a business call in the background.
Yeah.
They wrote that in a restraining order.
Yeah.
To try to get a restraining order. They lied.
And
does
anybody believe for a second that one person in this whole thing really wants a RO with this person, that they would really once if say it were granted, do you really think they would just sit back and be happy and they wouldn't be bothered anymore, so they would never talk about them again?
Nope. Well, to be honest, I'm just amazed that any of these people think that I care about this situation with Granny and everything, but the fact that any of them think that I care enough to break the law and go into court and stream is beyond me. Like it goes. My mind just.
Yeah, I mean, I know you well enough that if the judge says I don't want any cameras, blah 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 in the court, you're not going to like sneak one out and try to get a little shot. You're going to probably leave your camera or your phone in the car.
Yeah, absolutely, absolutely. I just had to deal with all of this in Forest City, Arkansas, in Troy Strope's case. I had to go to the judge personally and ask permission to bring a pencil and piece of paper into the courtroom.
Oh, really? Now that's a little odd, but I mean, they don't like distractions sometimes, and
right. But you see, I went through the correct channels.
Yeah, well, you asked permission and in a respectful way, and he's then likely to grant it, and he might give you a stipulation and try to keep it quiet, blah blah, or do it this way because he's there. He knows how it works, and he just don't want distractions.
Gave me permission. He gave me permission and told me he appreciated, me asking.
That's right. He respected the way you asked him. I mean,
it's that simple. But pay attention to what's coming up in this because honestly, this is something that we talked about whenever Trisha was covering this. That I brought up was res judicata, or however you say it. Which they blew their load in the lawsuit in Pennsylvania. What was it? 47 claims, including defamation and everything else. Right. Yeah. They blew their load.
They overcomplicated it.
Right. Well, no, they put so many accusations, including, RICO, all that good crap. But they put so much in the first lawsuit that I knew. Well, not only that, but Granny's got an ace in her hand whenever it comes to Tony Mathis. What a moron. In my opinion. Whenever it comes to Pennsylvania, they made so many allegations against Granny. It really is no longer in the judicial.
You didn't drug her in court up there. Now you think you can drag her across the country to another court?
Right, but it's for the exact same thing.
That's right.
You see what I'm saying?
Yeah.
So they blew it. I mean, any chance they had at suing for anything individually, that's on that list, they blew it. And now to go to another state to try to file a lawsuit based on something that's still being litigated in Pennsylvania? Come on.
Yeah,
You
it
know,
doesn't make sense. They don't change
it's
up venues. I mean, you're suing somebody, or you're in court in a battle over things, and all of a sudden the other one, file suit, and they're going to go forth back to their state. It don't work that way.
right. So let's continue on because it gets into that. And it's
All right.
really her lawyer did excellent with this. Excellent with this.
For protective order to prevent defendant from broadcasting as part of the active ongoing Pennsylvania appeal. Many of the matters in the plaintiff's petition here in Delaware County, Oklahoma, concern statements that were broadcast by defendant. Therefore, the Superior Court of Pennsylvania Eastern District has personal subject matter jurisdiction over defendant in this dispute over statements that were broadcast, and not this District Court of Delaware County, Oklahoma, even if plaintiffs are proven to live in Delaware County, Oklahoma. Oh, thanks, Cash. 2, defendant admits portions of paragraph 2, denies portions of paragraph 2, and is without sufficient information to either admit or deny paragraph 2. Specifically, Granny's Watching is the name of defendant's YouTube channel, not intended to be an alias. Oh, I gotta turn you guys down. Defendant admits she resides in Delaware County, Pennsylvania, which is not to be confused with Delaware County, Oklahoma. Defendant admits she operates the Granny's Watching YouTube channel. Defendant admits she makes a living from her YouTube channel, a living that is too modest to describe with plaintiff's words, profits. Defendant denies actual malice. Defendant admits that from time to time, defendant utters, authors, publishes, and edits material, some of which pertain to plaintiff Tony Mathis. Plaintiff Tony Mathis is a public figure, or alternatively, a limited purpose public figure thrusting himself into matters of public controversy, specifically the highly publicized, suspicious disappearance of a child and the search for that same child. See attached Exhibit A, the Pennsylvania complaint in which plaintiff claims to be a national spokesman and therefore a public figure. Within Exhibit A, please reference page 2, paragraph 4 as follows. Plaintiff Tony L. Mathis is an individual in his official capacity as national spokesman. As you all know, that's from the PA filing. Exhibit E's were missing.
All of them except for a random person's driver's
Defendant
license.
is without sufficient information as to whether defendant marketed any material or what is plaintiff's definition of marketing. As to the remainder of the paragraph, defendant is without sufficient information to paragraph 3. Defendant denies paragraph 4. Do you guys want me to pull out the paragraph so we know what I'm denying, or we want to just go on? What do we think? Oh, I missed super stickers. I'm sorry. Ooh,
Patrix,
thank you
these
so much,
creations for
Gary.
you. Welcome.
Oh, Cash, cheer up, Charlie. I like that. Ma'am, please respond to email. All right.
As
Froggy.
a public figure, he's held to a higher
May I
standard.
use one video
too.
about Seth Rogers? Absolutely. Whatever you need. Yes? All right. 1 second. 1 second then.
Sorry, what was that, Wilby?
As a public figure, the way they treat you, you're held to a higher standard in the way they treat defamation. Because
If
they
you
figure
are
a public figure understands how the media and everything works versus a private
Well,
individual, and it's even a greater burden of proof.
here's the whole thing. When you make yourself a public figure, whenever you intentionally put yourself in the position to be a public figure or a limited public figure, you open yourself up to the scrutiny that
Right.
comes with that from the public and reporters
You're-
alike.
Exactly. And
Yes.
when you do fair use content, and you're doing an analysis or for educational whatever, everything basically you say is not stated as fact. It's stated as opinion and banner. You're not just saying in a definitive statement, this person is this. You're just covering a cat. You're kind of covering the whole situation. So I don't know how he thinks he's going to prove this. I really don't.
Oh well, they've kind of You'll see they've kind of overloaded this lawsuit too, and
Yeah,
basically
and I really
argued.
don't think it'll never be in Oklahoma. I don't think, and I really doubt it'll even be in Pennsylvania before it's all said and done. I don't think that. I think he'll dismiss it in its
Right.
tracks, but we'll see.
Yep. Okay. Let's continue.
Let me put up my little video to say we'll be right back. This video doesn't have sound, but you can read the screen, although it goes by quick. Because at the end of the day, don't ever forget, this was all done on this missing child's back.
February the 26th, 2024, Sebastian Rogers was last seen, went missing from his mother's and father's home. Sebastian was last seen wearing a black long sleeve shirt, black pants. Oh, it's going too fast. If you have any information about Sebastian, contact 1-800-TBI-FIND. And this is a picture of Sebastian. And you know what, will be through all of this, I have got to give Granny props, because even though they filed this litigious lawsuit against Granny's watching
Yeah,
on the back of Sebastian, she has never lost sight of him in all of this. So I have to
yeah.
give her props for that.
She's done a good job. I mean, she really has. And she, like I say, she stayed in her own lane. And I think that's helped her not to get tied into one person. And she stayed her own person.
Okay, so paragraph 4
Me
is,
too.
as a result, plaintiffs sustained damages within the territorial boundaries of Delaware County, Oklahoma, beginning March 27th, continue to the date on which this petition is filed, and continue permanently into the future. Yeah, okay. Absolutely, Lisa. I don't want to make it too small because I don't want others to there we go. That should work. Gosh, I can't stand her. Number 5 is the claim that jurisdiction, venue, or proper for Delaware County, Oklahoma. Defendants without sufficient information either omit or deny paragraph 5 because defendant does not have definite proof of plaintiffs maintaining a residence in Delaware County, Oklahoma. Defendant was made aware in the course of public controversies and matters of public controversy that plaintiff owns real estate in Delaware County, Oklahoma. And indeed, in paragraphs 30 through 35, plaintiff discusses his tangled real estate dealings. But defendants without sufficient information about plaintiff's actual residence. Where
Tangled being the key word. It's going to come up.
Plaintiffs sleep, vote, pay utilities, and what address plaintiffs have listed on their license. Paragraph 6 is plaintiffs
Absolutely, Trixie.
incorporate the foregoing paragraphs. Defendant denies paragraph 7, which says this lawsuit arises out of original and continued false and incorrect publications made by defendant. So defendant denies paragraph 7, and that defendant has not made false and incorrect publications. Defendant also denies paragraph 7 on the following basis. Defendant appears to be complaining about some matters prior to March 27th, matters that are complained of in the ongoing Pennsylvania suit filed October 18th. Dismissal which plaintiff is appealing in Pennsylvania as of the filing of this answer. Defendant denies paragraph 8. Plaintiff Tony Mathis is not a private citizen, but is a public figure and furthermore claims to be a public figure. Please refer to paragraph 4 above. Alternatively, plaintiff Tony Mathis is a limited purpose public figure and the same high bar for defamation applies. The issue of public figure or private citizen is argued further below. Plaintiff Tony Mathis is not correctly characterized in his reputation. Defendant reserves the right to submit as evidence material about the actual reputation of Mr. Mathis, which is not as spotless as Mr. Mathis would like to state. You need a popcorn, would you?
They're going to dig up dirt on him before it's over, I think. More dirt. I really do. I think they'll dig up something on him, and he'll wish he never got in the middle of all this. But we'll see. I'm not hearing you, Regina. I don't know if you're muted. I don't know if you're trying to say something. I don't know if you got tied up doing something.
Can you hear me now?
Yeah, I can now. Yeah. I wasn't going to
My
say anything. I thought,
headphones.
hey,
My
in a
headphones
second, I've
fell
got to
off.
answer a message. Somebody's chat keeps messaging me about something. If it kicks me for 1 second, I'll come right back up. I don't know if it's going to or not. So when you start this back with her, I'm going to answer this person so they
Okay,
won't drive me crazy.
you're fine. You
And
got the
if it
link.
kicks me, I'll jump right back up. I don't know if it
Yeah.
will or won't.
All right, you've got the link. But yeah, when we're talking about, salacious dealings. um I mean, come on, Tony Mathis, you were charged for being part of a Ponzi scheme, were you not? Did it not affect your entire family? I mean, you were literally part of a Ponzi scheme. Not my reporting. I'm not the one reporting on that. It's been reported on by others. I'm just saying that has come to light. And you're going to see more comes to light. Um Actually, a lot comes to light in this motion to dismiss. So, let's go ahead and continue.
Defendant denies paragraph 10. Defendant reserves the right to submit as evidence material about the actual events alluded to in paragraph 10. Defendant is without sufficient information either admit or deny as to plaintiff Tony Mathis' intentions. And number 12, defendant admits paragraph 12, and as the matter of the missing child is a matter of public controversy, as is Tony Mathis' role as national spokesman for the biological father, who is who is a suspect. So you know what happens when you come out here, Seth Rogers, and you tell the world you are a suspect? We then, as the world, take that you are a suspect. Put a 1 in the chat if you've heard Tony and Seth Rogers state that Seth Rogers is a suspect. Defendant denies paragraph 13 and takes issue with the description therein. Seth Rogers has been subjected to justified public scrutiny because Seth Rogers is a suspect in the disappearance of his minor autistic son. A son conceived when a biological mother was, oh no, that's wrong, but is a public controversy.
Yeah. Yeah. On Vinnie Politan, Seth come out and said,
Defendant denies paragraph 14, including characterization of Granny's Watching as an alias rather than name of defendant's YouTube channel. Oh, lots of 1s in the chat. Okay. You're not out there with your brother? Oh, he's trying to be a private figure. I know, Stephanie, but it's part of how they advertise, they not advertise, it's part of how they represented him. They need wipes for their shit on their mouth. What did they say he is? A suspect.
Yeah. Seth's own words. He was a suspect.
Seth Rogers and Tony Mathis said that he was a suspect.
Yep.
Defendant is without sufficient information to either admit or deny paragraph 16, but notes for the record that in paragraph 16, plaintiff Tony Mathis admits in paragraph 16 that plaintiff Tony Mathis volunteered for a task that would involve emotional sacrifice. So on number 16, this is what Tony writes. Despite the emotional and financial sacrifice he knew it would entail, Mr. Mathis began volunteering as Seth Rogers' spokesman and advocate in May of 2024. So right there,
before we go any further with this, it is very important to remember that Tony Mathis was not only the said spokesperson, national spokesperson for Seth Rogers, but do y'all remember the Caleb Harris case?
That's right. He worked with that kid's dad, and he did the same thing for him. And then they ran him off kind of near the end.
Yes,
But I think he saw that there's money in this, and I can play this part and start looking for these things, and I can go make money doing them.
Right.
He's not doing it out of kindness. I do not believe that at all. That's my opinion.
We know that this goes as far back with Tony trying to get in with people and be a spokesperson for people, all the way back to the Idaho 4 case.
Oh yeah, there's been that people dug in, and you're right. He dipped his foot in the little shallow end to try to see the
Yep,
possibilities, and he's
he
just
sure
learned
did.
more and more. And now I think it's every case he's probably going to do something like this.
Hey, Ellie. You guys, I'm gonna put, I don't know if any of you would like to come up here with me and Wilby. I'm gonna put the link in the chat if y'all would like to come up because I
Yeah, I just
recognize
said that's
some
who
of
I
you
sent a
people.
message to Ellie. I was telling
Yep.
her here. Uh, I
So
think
if
one
you
thing
want
they're
to come
doing
up,
right now is, no, and everybody's talked about Sebastian for a year and a half. That's every creator. They hadn't touched on any other case. It's just Sebastian. Suddenly that stops. They got to get people speaking his name, or any money they're getting off social media is gone. So I
yeah,
think a lot of these moves are out of desperation to, hey, nobody's talking about us, nobody's covering us. We got to do something to create some news. And really,
but
any
the
bad
problem
news can
is,
be good news. you know,
what will be the problem is they've already filed lawsuits to try to silence everybody about
I
Sebastian.
know their lawsuits make no,
It makes no sense.
logically, they just don't make any sense whatsoever.
Yeah. Oh, that's fine, Ellie. Thank you for being here, though. All right, let's get back to it a little bit.
Tony Mathis volunteered for a task that would involve emotional sacrifice, thus nullifying plaintiff Tony Mathis' claim against defendant for emotional distress. The inability for plaintiff Tony Mathis to bifurcate his emotional distress between a Pennsylvania lawsuit and this petition in Oklahoma is argued further below. I don't know. Is he still their spokesman? I don't know. It's a good question.
He signed up for a job, signed up for it, put himself in the limelight for a job that was full of emotional sacrifice as part of the job. But
Now
now
he's
he wants,
complaining about it.
yeah, now he's complaining about it.
Uh, and
Exactly.
I think he anointed himself as the national spokesperson. I don't think he actually uh, was called that by a group of people. I think he just started calling himself that.
Yeah, if I'm ever missing, Wilby, just promise me that
I'm
you'll
going to
let
be
me
your
stay
national
missing.
spokesperson, and I will
Wilby,
spokes.
just promise me
I,
that if it comes down to Tony Mathis being the spokesperson for my
yeah,
case, you'll let me stay missing.
I'm not going to
Just
be in on the searches. I'll be honest with you. I'm going to leave that to the ground roots people.
leave that to my chief.
Yeah,
You forget I'm part of the search and
they'll be in
rescue team.
communication with me, but I'm not going into the woods looking for you.
Right.
I'm
Wilby, it's okay. If
okay.
you want to, I'll tell you what, I'll hook you up. My crew will hook you up. You have it upon if I ever go missing. My chief will hand you the controllers to a drone, and you can sit in
Yeah.
the air conditioning and look for me.
And
Okay.
Seth could ride that little thing he was riding on that where I seen him riding today. It looked like a little grocery store go kart, as I call them.
Oh, I
If he
don't
could
know
get that
nothing
thing where
about
he could
that.
get out in the woods and search, they'd never get him stopped searching. But he's not going to walk on his own 2 feet out in the woods and search for. He's not going to cover any distance whatsoever.
Yeah.
He
I
can't.
just, it doesn't
It
make
takes a
sense
fit
to me.
person to get out in the woods and run around and walk around in the woods and a lot, methodically search an area with a lot of other people in coordination. It's just
Yeah.
not for every. I mean, you can't just show up at
It's hard work.
an edge of a forest with 12 people. Who goes go searching? It don't work that way.
Yeah, no, if you're not trained, like if you have no idea what's going
Yeah,
on in any kind of training, don't get me wrong. You can take volunteers and go out there and do a successful grid search, right?
yeah,
But whenever it comes to some of the terrains and stuff, especially like we have in Arkansas that we have to search for people, I
yeah. It's
just, if you're not prepared and you don't know how to handle the terrain, then you're just as good as a fish out of the water
like I say in
out
the
there
hot
trying to
summer
search.
months, if you're not absolutely physically fit in good
Yeah,
shape, you can't run around walking through the woods sweating, perspiring, losing all your fluids, and paying attention to where you covered and where you haven't. It's just
right.
not. It's not for amateurs.
Yes, he did, Connie. He made himself involved. Very, very much so made himself involved. All right. So let's get back to it because boy, we just keep on, don't we? We'll be mean. We get together and we
Yeah,
don't ever
I'm not
shut up.
walking. I'm not walking out the end of the driveway.
Okay.
Thank you, Cash. I do enjoy a good rebuttal. No pun intended.
Listen, it's no secret everyone's out here balling on a budget, but I'm not giving up my coffee.
One second. That's a good question. Yeah, Granny's watching. Defendant denies she publishes false and defamatory content. Defendant denies the content she publishes is intended to be salacious. Defendant asserts plaintiff must misunderstand the dictionary meaning of the word salacious, which, per the Webster, means arousing or appealing to sexual desire or imagination. Defendant admits she seeks to generate traffic on her social media.
Wait a minute. Wait a minute.
I mean,
What?
okay.
I mean, don't get me wrong. Granny's a hottie, but I really don't think salacious is the right
mean,
term.
she's not live streaming in a bikini or
Right. She no, that does not that's not even what? Sorry.
I think the salacious part happens over in what's they call it is 2 a.m. TikTok girls or something that Tony hangs out with. That might be salacious. I don't know. I've never been there. I've just heard things. I don't know what they do, but the way they talk about it, it seems like something's going on.
Right. Well, you could call the TikTok stream where Tony exposed himself to the public.
That was not good. I mean, I don't know what he was thinking.
No.
I guess he thought that Button was gonna be off and the green screen went, and I guess the people
I do not know. I do not know what he was thinking. All I know is it was wrong. So, yeah.
But he's a national spokesperson.
Yep, national.
I'll remember that.
Right. And the things that Granny have said is got to be what's causing him all his trouble, because it can't be his own actions, right? Right. Okay.
Media channels, but defendant denies she publishes false and defamatory content, nor publishes content deliberately intended to be salacious, which means sexual desire. Tony, nobody's putting Tony and sexual desire together. Okay, rest assured.
Nobody. Promise you.
Defendant cannot understand plaintiff's oddly worded assertion defendant is seeking traffic upon online payment apps. What would it benefit defendant to have members of the public viewing her payment apps the way members of the public view defendant's YouTube channel? Right. Defendant denies she has ever published content about plaintiffs on Facebook and barely makes use of Facebook for any reason. Defendant's TikTok channel only has one video about a man chasing a fox away from his puppy. There's no content about the plaintiff.
So, in case you're missing what she's saying, okay, Tony has accused her of making these defamatory statements on, I think it's Pinterest, Facebook, and TikTok.
Yeah.
Platforms that Granny doesn't even use.
Does she do anything other than YouTube? But I don't know. I don't know of anything, but I don't know everything either. But
well, you heard that, didn't you?
Yeah, I mean
one of the channels he's saying that she's made these defamatory comments on was on a channel that only has one video of a squirrel running up the tree. I mean, this is starting more and more to look like the injunction out of Pennsylvania.
I think Tony basically
the only what are they called? Exhibit was a picture of a random person's driver's license. Yeah. Man, I'd be embarrassed.
And they got Hong shoes. They got pictures of Hong shoes, don't they?
Will be.
I've heard about these shoes so damn many times. I don't give a damn about what kind of shoes he's wearing. I'll take them off and beat him in his head with them.
Will be.
I don't care a shit if they cost $5,000 or $10,000. They're stupid looking, and he looks like an idiot wearing them.
Yeah. Well,
these are my $1,000 shoes. Look at my $1,000 shoes. Okay.
Oh my goodness. Yeah.
I mean, it's comical.
It is. It's you got to laugh at it, but honestly, I mean, yes, we can all laugh at it. You know what I'm saying? Because we're on the outside looking in at how ridiculous it is.
Yeah.
But can you imagine actually being Granny and the
Here's
hell she is going
the kind of person that styles a set of $1,000 pair of shoes does not run around and say, "Look at my $1,000 pair of shoes." They basically don't even mention it. It's just they just wear them. He's got to mention it every time you turn around.
Man, I'd be embarrassed to wear $1,000 pair of shoes because I know there's kids that are hungry.
I I wouldn't be embarrassed, but I find I can get Skechers right at a decent quality price, maybe less than $100, and they're fine for me.
Hey, look,
And I got
I've
950 more dollars.
I do have some shoes that are upwards
Yeah,
$300, but I've also had them for 8, 9 years and they're still in good shape. It's
yeah.
quality over quantity.
When I played
But
golf, FootJoy would send me a bunch of shoes, and they send you about a dozen pair a year, and they're high dollar shoes. They're like $200 or $300 a pair, but they sent me a pair of alligator shoes one year, and I don't know what they were high, but
hey, I got a pair of black, they're basically indestructible stilettos.
yeah,
Like you can wear them on gravel, and most stiletto shoes, like the tips will come off in the gravel and it'll start fraying and all. Not these babies. No,
yeah.
sir.
You see the movies where the lady steps in it, like gets stuck in a grate or something, and she finally she breaks the little thing off in it, her shoe. It happens
Yeah,
all the
no,
time.
that's not gonna be me. Not
No,
my
you
stilettos.
got the ones that are carbon fiber.
Yep, I sure do. How'd you
Uh,
know?
well, you said they were indestructible. The only thing I could think that would be truly indestructible would be carbon fiber, and then but
Yes,
the
the
only way you could
hills.
destruct it is basically hit it with enough force that there would be no shoe left for no person either.
Yeah, but you're right. They're coated in carbon fiber. The hills of
Yeah,
them are so that they don't fray and stuff. Yeah, cool. Okay,
yeah.
let's continue. Get me excited talking about shoes, Wilby. I'll never shut up.
Wear a pair of carbon
And I
fiber
have no
shoes.
Pinterest and found nothing of interest because I have no Pinterest. Tony said that I published stuff about him on Pinterest, Facebook, and TikTok. Who uses Pinterest? Do people still do that? The plaintiffs are throwing around accusations without basis. 20, defendant admits paragraph.
Stranger Ranger, me too. And don't let me don't let me get started. You guys. I have upwards over 100 pair of shoes. Okay, don't judge. Don't judge. We listen and we don't judge.
20. In 2000 or 2001, Mr. Mathis and his infant son were traveling in their vehicle when they were struck by an uninsured driver outside St. Louis, Missouri. Except to the assertion of who struck who, regarding which defendant is without sufficient information to admit or deny who struck who in a traffic incident. Defendant admits to the substance of paragraph 21. Mr. Mathis was transported from the accident scene to Missouri Baptist Hospital in Sullivan, Missouri. The hospital is currently known as Missouri Baptist Sullivan Hospital. Defendants without sufficient information either admit or deny paragraph 22 regarding whether plaintiff had health insurance.
Roommates or room with a view?
Ooh.
I don't know. We'll be roommates or room with a view.
Who knows?
Who knows?
Defendant admits
I'll
paragraph
not tell.
23. Missouri Baptist Hospital sued Mr. Mathis, collected medical debt, but the hospital later dismissed the lawsuit. Defendant admits paragraph 24 that defendant previously used the phrases robbed a church and was sued by a church for a large sum of money in association with plaintiffs. Defendant argues below the legal standard for defamation of public figure, which makes such phrase non-defamatory commentary on issues of public controversy.
I agree, Trixie.
I want to get to the good stuff. This isn't the good stuff.
100%.
Defendant denies all information concerning the hospital lawsuit was available to defendant or has to date been made available to defendant. Furthermore, defendant was one of several individuals on YouTube who characterized the lawsuit by Missouri Baptist Hospital with the words sued by a church. Defendant was not the first individual to speak those words. Plaintiff's paragraph 25 implies only defendant and defendant alone spoke or wrote those words, but that is not the case. I admit
It is very much so not the
I mean,
case.
if the hospital sue you, you literally have to pay them nothing, and I don't care how big your bill is. If you pay anything each month, I've always heard this. They stay off your back.
Yeah.
No, I mean,
That's
and
not
how's he going around with no insurance? That makes sense, doesn't it? No, that's
no,
crazy.
it doesn't. That's crazy, especially
Man,
having a child. I mean, I just don't understand not having insurance. But listen, here's the thing though, right? Granny is not the one that initially reported on that. And the thing is yes, Tony Mathis was sued by an entity, and it's fixing to come up in the video. Whenever it gets to the name, oh, it's Missouri Baptist Hospital, right? But
Yeah.
it was just Missouri Baptist on the thing, right?
Yeah.
What would you think if you heard
Well,
Missouri
that's like
Baptist?
around
Would
here
you
we
think
have Wake Forest Baptist Hospital. That's what
right,
it's called. It's a
right?
huge, wonderful hospital, one of the best in the United States. Uh, but
Well,
that's,
my children were born at Arkansas Methodist.
there you
Would you
go.
think that that was a hospital, or would you think that was a church? If I didn't tell you
I
my children
mean,
were born there,
uh,
if we were having a conversation and I said, "Hey, you want to go see what's up at Arkansas Methodist," what would you think? Where was I inviting you?
uh, if I weren't listening to preaching, I would not assume that it's a church, because I've known. I mean, there are a lot of you got the Duke. Duke used to be affiliated. I mean, a lot of hospitals are affiliated with
Churches,
denominational.
right?
Uh, uh,
Right.
but you know, like I say, we right here 10 miles from here, we got Wake Forest Baptist Hospital. It is the largest employer in Forsyth County, and where RJ Reynolds Tobacco Company used to be, they used to employ like upwards of I don't know how many tens of thousands. Now Baptist Hospital has taken that over. They employ more than anybody. That's how big it is.
You know what? I bet the name of my church really confuses people. Bethesda Worship and Healing Center.
Yeah, they might get you really mixed up.
They might mistake my church for a hospital.
They might think it's some kind of healthcare facility.
Right.
Yeah, they heal people over there.
Crazy.
Let you rest up and get all fixed up and go back to work.
Yep. I mean, I can see the misconstruement. I can see the misconstruement. But the thing is, well, we'll get into it because it's all explained right here. And Granny does such a good job. So,
Paragraph 26 regarding discussion broadcast on the Nonsense YouTube channel. Nonsense. If you want to come up and read with me, you can. I think switching voices may help the people pay attention longer. Am I reading too fast, by the way? Because I can slow it down. The discussion was in regard to a matter of public controversy. Defendant missed all paragraph 27 except for the word defamatory, which defendant denies. See argument below regarding the legal standard for defamation of a public figure or a limited purpose.
pay attention.
Defendant denies paragraph 28, which is, and puts the plaintiff to his proof. So 28 is that defendant also made statements during the live broadcast falsely accusing Mr. Mathis of enlisting other social media accounts to dox the defendant. You know how I know Tony lied about that? Because I never said that I was somebody that Tony had TikTokers, in my opinion, set out to dox. If you all recall, and many of you do, two ladies from TikTok that used to be part of the 2 a.m.
Okay, I was there, so I can speak on this. They came up and said that Tony was gathering information, okay, to try to dox creators. But Granny wasn't even mentioned as one of those creators. I was there during that live. I know who she's talking about, and I know what she's talking about. And it had nothing to do with Granny at that time. Nothing. We didn't even know about this, any of this going on. Like, none of YouTube did. So, yeah.
crew.
Did you want to say something, Wilby?
No, I was just I had a song in my head, and to be honest with you, I was about to start whistling, and I realized I was on a live stream, so I better wait.
Had came out, and they said that Tony encouraged them to dox content YouTube creators, right? Anybody else remember that? I never said that it was me because I was not on their radar at that time. I wasn't on the radar for these guys until Brittany Jackson called Nick on the day that she denied calling Nick. And then 30 minutes later, admitted she called Nick. So, yeah, well, you're going to have to produce proof of that, Tony. Defendant denies paragraph 29, which is in a community post or YouTube channel, defendant again publishes written statements falsely accusing plaintiffs of the fraud in the church as shown in the following image. So I deny that because I did not publish a statement. The so-called statement was filled with question marks. The words were questions, not statements, which is shown in their own proof. Yes, she is, Kane. Yes, she is.
Sorry, you guys. I'm budgeted for my entertainment,
She
and
just won't splurge and get the premium.
nope, I won't splurge.
I
and
don't
get the
blame. I
premium.
don't blame you.
Listen, Wilby, I cannot give up Hulu. Okay, I can't do it. Don't ask me to.
I don't blame you.
30 is defendant published a live broadcast entitled a live broadcast entitled Tony Matheson's wife commit fraud. And they only put an exclamation point. They didn't put the question mark. So, and that plaintiffs have once again deceptively omitted a question mark to deliberately mischaracterize a question as a statement. Plaintiffs have also committed the keyword did. The sentence actually reads, did Tony Matheson and his wife commit fraud? They put Tony Matheson's wife commit fraud with an exclamation point, completely lying about the title of that live stream.
Oh,
I deny A, B, C, D. A is deliberately misquoted. Sentences are missing between other sentences, but deceptively, plaintiffs have not inserted ellipses. The timestamp is incorrect. The quote was said at 54:12, not 53:20. Would it be a good idea to write that?
did Joseph Lesniak
play it,
help
I
him
mean?
write this
You
law?
think they'd
Something
hire
on it,
somebody
right?
to type the
I wish I
transcript
could play it for you all.
accurately?
You'd think they could get a competent lawyer
I mean,
to actually look into
if
what
I
he's
was going to go to
filing.
trouble to sue somebody, I would have a lawyer that would at least cross his T's and dot his I's and do everything properly.
No kidding. Wow.
I mean,
Mm-mm-mm. And they treat it like it's a joke.
they act like it's some kind of like a child. I don't know. I can't even compare it to anything. It's a waste of time. I'm telling them. Both sides is a waste of time.
Trixie,
I hate to tell you, even if they get a judgment by the judge on the slap thing, the odds of Granny and Barbecue, and I hope both of them get $1 million each. Now, let's make this clear. I hope Tony has to dig all his money up and give it to them. But if they've got good attorneys, it'd be a cold day in hell for one of them actually hands over their money to them. I'm telling you, mark my word. And I don't want it to be that way. I want it to be the opposite. But that's just the way the courts and liens work. Judgments work.
yeah.
There's a million ways you can legally delay it. You can file bankruptcy. It doesn't get rid of it, but you can make it take forever to people just about give up.
In my honest opinion, and this is just my opinion, you guys, I'm not accusing anybody of anything. I'm just giving my opinion. In my honest opinion, it's sad because this is a wagon wheel that is turning slowly and always ends back up at the same place,
That's right.
falling off the rest of the wagon.
Yeah.
Okay. Because here's what's going on. He thinks he's gotten in this hole. Well, I can just do and make some money because he's had. I mean, look at what they just did with this. This frivolous litigation in Pennsylvania. But now he's going after her solely, and he's thinking, well, I'm in my backyard now. I can sue her and I can win. But here's the thing: is it really his backyard? Because, like I said earlier, they basically blew their load. They put what was it, 47, 49 accusations in a lawsuit against Granny, and 50 and Barbecue, and 50 does.
Yeah.
50 that they started naming in restraining orders, including yours truly. But listen, I just want to say this. This is so important that I say to all of you who think so highly of yourselves that you would assume I cared enough to cause problems in your life. Bless your hearts. Bless your hearts. That's all I got to say. Bless your hearts. Okay. Now, Where was I? I got lost on my little rant.
Tony and his
Oh, yes. Here's the thing: it's a wagon wheel. It keeps spinning, and once it gets back to the same spot, it falls off. Right?
yeah.
It's broken. Um, with Tony, he has a history of being involved in scams and stuff like that.
Yep.
Okay. If he hasn't learned anything from trying to, con people, now he's
Yeah.
trying to use the courts to silence people, right? And deny people of their uh very constitutional rights, along with earn money from frivolous litigation. It's not going to stop. Like, where's the next con going to come into play? What's the next get rich quick
Ah,
scheme that he's going to employ on someone else, possibly after he's done losing? Because Granny's going to clean the floor with him, y'all.
yeah, he's seen something, revenue streams that we haven't seen, or we can't even think of, but we don't, not even thinking about, and he's just clicking along, I think.
Right. He has absolutely targeted her.
This can't be fun unless you're making a lot of money doing it.
Yes, Trixie. And see, that's something else. If anyone has any kind of defamation lawsuit in all of this, it's Granny, who was accused of committing one of the
Being
highest
salacious.
felonies. No, not only that, but one of the highest felonies, a RICO. A RICO, Wilby. They accused her of organized crime.
Yeah, with a
for
woman she
having
had
an
never basically
opinion.
met or knew anything about
Yeah,
until they were put together on a lawsuit. So how were
right.
they organized together if they didn't know each other?
Exactly.
You do this and I'll do
Exactly.
that, and we'll make all. They didn't even talk.
Yeah,
They didn't know each other. They knew zilch about the other.
right. They might have had contact one time coming across each other on
Different
YouTube or
platforms,
something.
TikTok
Yeah,
versus
or different
YouTube.
platforms
She's TikTok.
involving true crime,
Yeah,
right? In Sebastian's case. But Rico?
it might have been somebody they had heard the name, or I think I've seen her once or something. You know what I mean? But they didn't know one another.
Right. Well, it's almost like they want to say that because people have a collective opinion, right? Because they've all witnessed things for themselves. And it's almost like they're trying to say that because these people have a collective opinion about him because of his
Oh,
actions and behaviors, that it's an organized effort to commit crimes against them. What? What? Are you kidding me? How's what?
yeah. The only thing this whole the story has taught me: if your child ever goes missing, keep YouTube and social media, like for the most part, far away from you as you can. I just don't. There are some creators who will do nice work and get the word out, but if you get involved with the entire community, it's going to turn into a shit show, in my opinion. And that's sad. It doesn't have to be that way, but that's pretty much the way it's been for a pretty good while now.
Exactly, Connie. Who's the next victim? Does it stop with Granny? I mean, we've all seen this pattern before. If you really think about it, we've seen this pattern before. It's already turning ugly. Do y'all know how many YouTube creators are down because of a strike wars allegedly with Britney during all of
They're
this?
falling like flies right now. I think
Yeah,
Johnson got struck tonight.
right.
Her stream said video available in about an hour and something in,
Yeah,
with no
Trisha's went down
warning.
too, I'm pretty sure. It's crazy.
Oh,
It's crazy. Who wants to be next for having an opinion and wanting to do something to help a community find a missing kid? Or have an opinion based. I mean, seriously. It was all fun and games for everyone whenever they were going solely after Chris and Katie, wasn't it? Didn't have no problems in the world whenever everything they were doing were being picked apart. Let's get right about that, right? Okay, no problems with it at all. But then whenever Seth decided that he was going to put himself on a public platform And
Tony
people
got
were
involved,
going,
and all of a sudden there were teams. You're
right,
on this team, and they're on that team, and we're not working at the same purposes.
right.
We're
But here's
working
the whole
against one
thing.
another, and
Will
explain
be
that how that's beneficial to Sebastian in any
anybody.
way.
It's not
I,
beneficial to anybody.
it's quite the opposite.
It is. It's very much so the opposite. But you got to think about it like this. It was all fun and games, and it was fine and dandy for anybody to say anything they wanted, no matter how ugly, how untrue, how unsupported by any kind of evidence a claim was against Chris and Katie, right? It was okay to pick everything apart. But as soon as that table turned, because Seth made himself a public figure, as soon as that table turned, whenever he started putting himself and out there in the public eye, and he started getting scrutinized for it, only then did attacks start happening on creators, etc.
Yeah,
Right down to subscribers to creators. It was awful. And the thing is this platform, you guys let me tell you how important this platform is. There are families out here that don't have anyone talking about their cases. Okay, do you know why? Because people are being silenced. Everyone's been silenced. People are afraid to talk this, that, or the other. So whenever someone is willing to actually pick it apart unbiasedly for tit for tat is what it is, and lawsuits are being filed against them, no,
yeah.
you're shutting down the entire topic. It's not just about not talking about Sebastian being missing anymore because Seth is filing lawsuits against people. It's everyone afraid to talk about anybody's case, even just to try to help and get the
Oh, my
word
chair
out
just broke.
because somebody doesn't like what was said. Are you okay?
Yeah, I'm okay. It's got a thing in the back, and I just replaced it, and it was supposed to be a better part. And when I looked at it, when I put it on the other day, I thought that looks like cheap. It was hardly welded at all. And I questioned it. And here's the thing: when I bought it from Amazon, it had, they'll have the thing. This is a high return item. Why I bought it, I don't know. But it just did exactly what the person said it was going to do. He said it broke the second day he had it. I've had this thing. Today is what, Thursday, Wednesday? I got it on Sunday.
Take it back. I'd take it
Oh,
back.
I'm going to. But I thought,
You already know.
hey, I get it. And if it turns out to be what they say it is, but if it's what the customer say, what one customer says it is, they'll give me my money back.
Yep.
Yeah.
All right, Wilby. I got so far off there. We're gonna get back to the video.
All right, I'm
But
on
I don't
mute.
know if they could use that to say
Me too.
rebroadcasting the statements or something. The statement is out of context. Furthermore, note the tone of actual belief in the statement, which nullifies the accusation of actual malice. Again, the statement has the wrong timestamp. Furthermore, the statement was not in reference to plaintiff's $1 property transfer, but refers to a different matter, a matter in which plaintiff admits he involved his relatives in a Ponzi scheme. So what they did there is, I'll show you guys. On C, it's not C, it's D. On D, they wrote, Tony just involved, you're right. He involved his in-laws in fraud. Tony is a fraudster through and through. Tony is a religious in and out of the courtroom frequent flyer. That was a quote from me on that day. That was the quote. So they put that in here as if I was referring to the quit deed, but I was actually referring to the Ponzi scheme because the sentence goes on to mention the Ponzi scheme in which Tony himself admittedly involved.
Okay. So do you know what a Ponzi scheme is, Wilby? A
But it is.
Ponzi
It's
schemer
they take
is
from
an
one person.
individual.
They got to keep get new people into it so they can take from them to give to the next person, and eventually they stop giving. They're only taking.
Yes, here's the whole thing. A Ponzi schemer is an individual who perpetrates a Ponzi scheme, which is a fraudulent investment operation that pays earlier investors with funds from newer
That's right.
investors.
And Tony got
Rather than
called to
rather
pay.
rather than from actual profits. Go ahead.
Yeah, there's a phrase they use. It's basically they claw back from people that actually did get paid when people were getting paid, because when they stop paying them, and and the people get money took from them, they actually take money from the ones that got paid. And Tony was one of the ones who got paid. They took money from him to give back to the ones that got cheated. They got a phrase for it. I can't think of it right offhand. Clawback, I think, is what one of the phrases they use.
I don't know how it all went down or what. I just
I
know
don't
Tony
either, but
was absolutely a part of a Ponzi scheme. He
yeah,
said that.
they got clawback from him, which basically he did get paid. He got the promise of the profit, the dream. What they said, other people did not. They were waiting on their money, but the courts got clawback from him to take care of some of those people, and it was quite a bit of money. He tried to downplay it the way he described it, but I didn't buy it.
Okay. It's crazy.
Yeah, it is.
Defendant believed the statement when it was made and continues Ponzi scheme. So what they did there is, I'll show you guys. On C, it's not C, it's D. On D, they wrote, Tony just imbibed. You're right. He imbibed his in-laws in fraud. Tony is a fraudster through and through. Tony is a religious in and out of the courtroom frequent flyer. That was a quote from me on that day. That was the quote. So they put that in here as if I was referring to the quit deed, but I was actually referring to the Ponzi scheme, because the sentence goes on to mention the Ponzi scheme, in which Tony himself admittedly involved his family when he went on a podcast to defend himself against it. Defendant believed the statement when it was made and continues to believe the statement. That is, he's trying to avoid debt is the statement. So on that date, I said he's trying to avoid debt. They put in here that I believe the statement when it was made and continues to believe the statement. Defendant denies paragraph 32, which is, defendant's statements were false and she should have known they were false. So defendant denies paragraph 32 and notes plaintiffs have destroyed their own allegation of actual malice with their should have known argument. So when you write in there that I should have known that that was false, you're essentially admitting that I did not know, and therefore I did not do it with malice. Is the argument that my attorney is taking on that. So for the people that are saying, proof of attorneys, I think this is pretty significant proof. There's many pages in here.
Oh, I can't imagine how much she paid her attorney. I cannot imagine how much she paid her attorney.
Right? You guys get how they null their own argument that it was malicious?
This is a 46
when you state that I should have known. Defendant denies plaintiff's recitation, facts, and also denies plaintiff's slipshod summary of Oklahoma law. There's a statutory requirement in Oklahoma to declare the actual value of real property sale for tax purposes, argued further below. So number 33, it states, as later explained to defendant in a cease and desist letter, Mrs. Mathis' parents are building a home on property where plaintiffs keep a shop and office, and that plaintiffs sold half that lot to Mrs. Mathis' parents for fair market value. That letter also explained that Oklahoma deeds regularly recite considerations of $1, and that the deed language does not state the actual purchase price. A copy of the check from Mrs. Mathis' parents to the plaintiffs was enclosed with the letter, and that check image proves defendant's statements about selling a house for $1 were false. There's a statutory requirement in Oklahoma to declare the actual value of the real property sale.
What wasn't it listed as $1, like a quick deed exchange, though, in public records, or am I wrong?
Yes, it's public records.
Yeah, and then he claimed, well, they give us a check as well, or something. I don't know. I think it's a bunch of
from what I come to understand, the check was dated differently. Not
I think that was after it all got attention brought to it. Kind of a knee jerk reaction. I think he might be afraid that SLAP's going to make a judgment against him and he wants to start hiding assets. Well, he ought to know he can't hide that asset by doing that. But I don't know. It doesn't make sense.
Yeah, I don't understand. Look, these lawsuits are some of the most ridiculous stuff I have ever
Oh
heard.
yeah,
in
he's
this
afraid.
building.
He's afraid Pennsylvania's going to throw a judgment on him, and then
No,
he's
he
got a nice
knows.
lake property. Yeah.
Will be anyone. Listen to what I'm telling you.
Yeah.
Anyone with half a brain
Yeah.
knows that Pennsylvania. Look. I'd love to be a fly on the wall whenever they're discussing it. Whenever the judges are discussing
I
it.
think that
I
judge
would
is going to make a first case. Show everybody this is how we're going to do business. Don't come to their state suing people. Don't be suing people frivolously and having it come back on you.
Granny has a screenshot of Tony Mathis saying he was going to sue her and continue to sue her.
Yeah.
He did not care even if he lost.
Just to irritate her or
This is not
something.
even, no, Wilby, this has
Well,
gone beyond lawsuits. This is
yeah.
harassment. This is a crime.
Yeah,
This
just to
is
bother
a
her is what he
crime.
basically said. He didn't care how much money it cost him if won or lost, but just because he could,
Yes.
it would bother her.
Yes. It is absolutely a crime what they are doing to Granny.
That statement right there alone makes the whole thing a slap case.
Yes, it does.
You're not suing the person based on merit. You're suing because you got your feet hurt, and you think your
100%.
power is you got more money and a better lawyer, and you're able to harass this woman in the courts just because you can. The courts aren't meant for stuff like that to be happening.
Right. But do you see the kind of tactics they're playing? They switched. They took out one word and a question mark.
Yep.
They took out a word and a question mark to twist the narrative.
Yeah. I don't really think Tony's as smart as he thinks he is. I really don't, because you don't say something like that and then knowing that they've got an anti-slap law. I mean, you basically convicted yourself of frivolous lawsuit just by that statement, in my opinion. I'm not a lawyer. Find a lawyer and they'll tell you what they think.
Whew. All right, let's continue.
Oklahoma law. There's a statutory requirement in Oklahoma to declare the actual value of real property sale for tax purposes, argued further below. So number 30, on that date, I said he's trying to avoid debt. They put in here that I believe the statement when it was made and continues to believe the statement. Defendant denies paragraph 32, which is defendant's statements were false and she should have known they were false. So defendant denies paragraph 32 and notes plaintiffs have destroyed their own allegation of actual malice with their should have known argument. So when you write in there that I should have known that that was false, you're essentially admitting that I did not know and therefore I did not do it with malice.
Bing bong.
I think it's a very well written.
Is the argument that my attorney is taking on that.
Yes,
document.
and that's
So
it's
when
not
people
too
are
complicated.
saying,
It sticks to point, and the average lay person can understand it.
yes, exactly.
And that's
It's
who's going to be
written-
on a jury. If it gets to that
It
point.
is
I don't think
written.
it will.
I don't think it'll ever make
I
it.
think it'll be dismissed.
I think it'll get quashed.
Yeah, I do too.
I think it is so well written. I think it serves as a good example, though. I mean, this very lawsuit is, I'm telling you, Granny's got a good cause to file harassment at this point, in my opinion. This has gone beyond, I mean.
When you make a statement like he made, when a judge reads that and he sees and verifies it's a factual piece of evidence, he's gonna give Tony Mathis a tongue lashing that he's not gonna like. He's gonna dress him down real quick at the end of the trial.
Yeah. All right, let's continue.
You know, proof of attorneys. I think this is pretty significant proof. There's many pages in here. Right? You guys get how they null their own argument that it was malicious when you state that I should have known. Defendant denies plaintiff's recitation, whatever, facts, and also denies plaintiff's slipshod summary of Oklahoma law. There's a statutory requirement in Oklahoma to declare the actual value of real property sale for tax purposes, argued further below. So number 33, it states, as later explained to defendant in a cease and desist letter, Mrs. Mathis' parents are building a home on property where plaintiffs keep a shop and office, and that plaintiff sold half that lot to Mrs. Mathis' parents for fair market value. That letter also explained that Oklahoma deeds regularly recite considerations of $1, and that the deed language does not state the actual purchase price. A copy of the check from Mrs. Mathis' parents to the plaintiffs was enclosed with the letter, and that check image proves defendant's statements about selling a house for $1 were false. There's a statutory requirement in Oklahoma to declare the actual value of the real property sale for tax purposes. Defendant admits defendant was personally served a cease and desist letter by process server, which in effect told defendant cease comment on a matter of public controversy involving a public figure or limited purpose public figure. The letter was an attempt to intimidate and silence free press. Made me drop my damn complaint. It's amazing how it doesn't matter what
absolutely
state you're
is.
coming from. No, this isn't the same lawyer Julie called. No. Doesn't matter what state you're in. People have a right to free speech and they have a right to discuss matters of public concern. And this is no more different than what happened in Pennsylvania. And I'm actually just reading this for the first time with all of you. So forgive me for my excitement, but it is true. Thank you, Miriam. You can't silence free speech. I printed press pass for Jess on my inkjet printer today. It's going to be epic. BJ, this is what is meant by receipts. Now show us yours, not a freaking invoice. It is. This is America, and Ellie asked for the public's assistance in Sebastian's case. This sure is not defamation. Doesn't he understand? Yeah. Hey, Scooter. Oh, no, Kane. So defendant denies paragraph 35 and urges comparison between 35 and paragraphs 23 and 25. In paragraph 35, plaintiff claims the C&D proved plaintiffs were not sued by a hospital. And in paragraph 23-25, plaintiffs plainly admits being sued by a hospital. Plaintiff further denies property records were sent as a part of the C&D, as plaintiffs assert, which is true. They did not send me property records. It's not. I don't know why they even claimed that. Defendant admits in part and denies in part paragraph 36. Defendant admits the C&D requested retraction and apology, but defendant denies her statements were defamatory. In response to the C&D, defendant went live on her YouTube channel and issued a correction, saying plaintiffs was not sued by a church, but a hospital. At the time, however, defendant was unaware the hospital was called Missouri Baptist Hospital, and a retraction was unnecessary under the defamation standard applied to public figures.
I saved $120 a month on my car insurance.
Limited public figures. Defendant denies plaintiff's false statements and deliberate mischaracterization in paragraph 40. I need that ad revenue, babies, was not a statement concerning plaintiffs. Instead, defendant was referring to the practice of YouTube demonetizing videos, disallowing ad revenue, if the videos included copyright music. Defendant was referring to not using bits of copyrighted music so as to avoid her videos being demonetized.
She sure was.
Defendant denies the cartoon is a false accusation of fraud. The image is commentary on an issue of public controversy. Defendant denies she published a cartoon. The original artist of the cartoon published the cartoon. You guys know the little figure of the person holding a C&D? Oh gosh, low-key, I couldn't even imagine. And Bernice, I couldn't imagine that either. Defendant admits paragraph 42. Defendant refused to be intimidated by plaintiff out of comment on matters of public controversy. So number 42 stated, says, during a live broadcast on defendant's YouTube channel, defendant stated, fuck that cease and desist. Fuck that cease and desist. You didn't know that? So yeah, I was not going to be intimidated out of comment on matters of public concern. I deny 34, which states that the plaintiffs have suffered greatly. Number 44 is that Mr. Mathis' financial integrity, trustworthiness, and reputation is vital to his ability to maintain trust with current and potential customers and perform his chosen occupation. Defendants without sufficient information to either admit or deny
Oh my
paragraph
goodness,
44.
I hate to do this, but I
Defendant
gotta
does
say
not
something. Tony Mathis, nobody wants to hire you as a spokesperson because you showed your wee-wee on TikTok. There, I said it.
even know what job plaintiff has besides national spokesperson on an issue of public controversy. Defendants without sufficient information either admit or deny paragraph 44. Defendants not even know. Right, we just read that. Got it. I deny 46, which is self-serving rhetoric and puffery by plaintiffs. So 46 states, Mr. Mathis' trustworthiness and reputation are also vital to his voluntary work on behalf of the father of a missing child. That father, along with many other parents of missing children, rely upon Mr. Mathis to be a voice and advocate to raise a.
Who are these many? Will be. Do you know who these many are? Are you there, Wilby?
I couldn't. Unmute. I couldn't find my mouse unmuted.
Who
When
are
the chair
these
popped,
many?
it fell off the table and I didn't realize it.
Have you ever
I don't
known him
know.
to be a spokesperson for anyone other than Caleb Harris's family and Sebastian Rogers' father, Seth? I have. Who are these many?
I don't know. None of this makes any sense to me.
Me either.
He just
Me
got
either.
called out on something, and she just basically commented on a public record. It'd be like me commenting on your, if I looked up the property tax for the home you live in, or the just something anybody can access. Everybody can access it if they want to. She made a comment. He didn't like it.
Right.
Awareness and publicity for grieving families grasping a glimmer of hope of seeing their children again. That's what Tony's attorney wrote for 46.
Damn it.
So here's how we respond to that. It is self-serving rhetoric and puffery by plaintiffs. The claims of plaintiff Tony Mathis to be a voice and an advocate are squarely in line with his claim in ongoing litigation in Pennsylvania concerning the same subject matter and same defendant. To be a national spokesperson and therefore a public figure are eternally a limited purpose. 49 does not require admission or denial. I deny 50, 51, 52, 53, which are all these defamatory statements expose plaintiff to public hatred, contempt, ridicule, disgrace. These statements falsely accuse plaintiffs of crimes and moral failings, thus constituting libel. Defendant community statements to person other than plaintiffs. Those person reasonably understood the statements and accusations to be about plaintiffs. Defendant denies paragraph 53 in that the taint of false and defamatory and libelous and libel per se is intrinsically part of the phrase, the statements. All right, let's go down.
Intrinsically.
Defendant denies paragraph 47 and knows plaintiff have argued away their own case for actual malice. So 57 says, defendant knew the statements were false, should have known they were false, had serious doubt whether the statements were true or false, or should have had serious doubts whether the statements were true or false. So again, you can't say it was done with malice, but also claim that I should have known.
Wow.
Does not endorse plaintiff's statement of how the law is to be applied to these facts. Cherry picking statements free of context and claiming such statements can stand on their own as libel and slander is not how defamation works.
I think all he's done is done what he promised he would do, is sue her just because he could and aggravate her.
Yeah,
And,
just to aggravate her and
And
harass.
just he knows, Regina, I've got to deal with this chair, or I'm sitting here standing and I don't have enough energy to sit here and stand too long. I'm
Oh,
gonna jump
no.
off and handle this.
Alrighty.
It's gonna be interesting to watch this going forward. I just feel like this judge is going to give him a talking to at some point in this process.
Yeah. I figure I plan on going over this at least until 11, and then I'm gonna close it down for the night and do this in 2 parts if I have to.
Yeah, I'm sitting here standing right now, and I've got to. It's going to be a bunch of racket going on, and I can't do that and be on panel at the same time. It's a
Yeah.
lot going on.
I appreciate you.
I do.
Wilby.
I appreciate
It's
it too,
always a
and
pleasure having you.
maybe someday, maybe we'll get to see the judge put Tony in his place. That would be fun.
Yeah, really
Worth the
put
price of
Tony in his
admission.
place.
I'll pay to watch that.
I'd pay to watch that.
All right,
I would.
I'll
pay
be
to
watching
watch
from
that.
and listen in the chat.
Alrighty, I will see you later. Have a blessed night, Wilby. All right. Uh-oh. We got to go back a few seconds. Okay.
Attorney wrote for 46. So here's how we respond to that. It is self-serving rhetoric and puffery by plaintiffs. The claims of plaintiff Tony Mathis to be a voice and an advocate are squarely in line with his claim in ongoing litigation in Pennsylvania concerning the same subject matter and same defendant. To be a national spokesperson and therefore a public figure, or alternately a limited purpose. 49 does not require admission or denial. I deny 50, 51, 52, 53, which are all these defamatory statements expose plaintiff to public hatred, contempt, ridicule, disgrace. These statements falsely accuse plaintiffs of crimes and moral failings, thus constituting libel. Defendant community statements to person other than plaintiffs. Those person reasonably understood the statements and accusations to be about plaintiffs. Defendant denies paragraph 53 in that the taint of false and defamatory and libelous and libel per se is intrinsically part of the phrase, the statements. All right, let's go down. Defendant denies paragraph 47 and knows plaintiff have argued away their own case for actual malice. So 57 says, defendant knew the statements were false, should have known they were false, had serious doubt whether the statements were true or false, or should have had serious doubts whether the statements were true or false.
Okay, the reason this part is so important is because whenever you file a lawsuit of defamation against someone, you have to prove whenever that person is a public figure or a limited public figure, they have to prove that you maliciously, intentionally said untrue things to hurt their reputation, business, etc., etc. And then you have to provide proof of the actual damages too. But in this case, they're saying that the claim that they've made to the court is that it was malicious that she did this. But then they're coming back with, she should have known better. Well, which is it? Was she, what was this unintentional because she didn't know? Or is this malicious? And if this is unintentional because she didn't know, Well, that destroys your claim that it was malicious, because that's what you're stating to the court, is that it was malicious. Okay, let's continue.
So again, you can't say it was done with malice, but also claim that I should have known. Does not endorse plaintiff's statement of how the law is to be applied to these facts. Cherry picking statements free of context and claiming such statements can stand on their own as libel and slander is not how defamation works. Defendant denies she made false statements on the dates in question. Defendant denies statements made on those dates were published and republished and put the plaintiff to his proof, and denies the statements were false. Defendant denies she is the original speaker and or writer of the statements and puts plaintiff to proof. So 74 is
Putting the plaintiff to proof is literally saying, okay, you want to say it was this? Prove it, because that's not what happened. She's calling their bluff. I love it.
all of the statements that were made about the church, which we know now was a hospital. Defendant denies paragraph 76. The statements of defendant were not false and do indeed enjoy constitutional protection. 76 is said statements do not enjoy constitutional protection as they were made knowingly and or with reckless disregard for the truth. Defendant denies paragraph 84, which is that plaintiffs are entitled to judgment against defendant for actual and punitive damage plus costs, fees, and interest. Denies judgment should be awarded to plaintiffs plus costs, fees, and interest. Plaintiffs are no more entitled judgment in Oklahoma than they were regarding the same defendant and same subject matter in the petition complaint filed in Pennsylvania. See arguments below regarding jurisdiction and res judicata. He's a limited time purpose. All right. Denies paragraph 112. Defendant denies plaintiff's false statements
There
and
it
deliberate
is.
mischaracterization. Paragraph 1.
There's that thing I've been waiting on. Hold on. I want to tell you guys what that is, because I brought this up when I was over on Trisha's panel. I love Trisha Talks. By the way, you guys, if y'all are not subbed up to her, I highly recommend her. She's from across the pond. She's beautiful. I love her accent. She's one of those kind of people that, you know, keeps herself in check and really holds herself up to the same standards she does everyone else. I love that about her. So if you guys haven't checked out Trisha Talks, just go ahead and look her on up on the YouTube and go over there and tell her I sent you. Okay, so here's res judicata. Hold on. Res judicata, or claim preclusion, is a legal doctrine that prevents parties from relitigating claims that have already been resolved by a final judgment on the merits in a previous lawsuit. And here we go, this little thing called merits. These are some of the same claims, defamation, etc., that was made in the original litigation, the original injunction. I'm telling you, they put everything except the kitchen. No, I think they threw the kitchen sink in there into the lawsuit in Pennsylvania. Okay. I'm sorry. I was drinking soda. It requires a prior final judgment on the merits involving the same parties or their privies and the same cause of action. The purpose of res judicata is to promote finality in litigation, conserve judicial resources, and prevent the public harm that can arise from contradictory judgments. And that's what Granny is talking about right now. All right, let's get back into it.
112, which simply reiterates paragraph 40. I need that ad revenue babies was not a statement concerning plaintiffs. Instead, defendant was referring to the practice of YouTube demonetizing. Now here where we file Oklahoma participation. Oh, sorry, I wasn't looking at chat. Philadelphia freedom, Oklahoma freedom. Defendant makes motion to dismiss legal action based on a party's exercise of rights under 12 OS Oklahoma Citizen Participation Act. This motion is argued further below. Defendant makes a motion to dismiss upon grounds of lack of personal jurisdiction. This motion is argued further below. Dismiss upon grounds of lack of subject matter and jurisdiction. Defendant makes a motion to dismiss upon grounds of res judicata. Defendant makes a motion to dismiss upon grounds of forum non-convenience. Defendant makes a motion to dismiss upon grounds of frivolous and fictitious litigation based upon a documented admission by the plaintiff, which is part of the record in Exhibit B, the Pennsylvania dismissal. This motion is argued further below. Defendant makes a motion to dismiss on the grounds of estoppel. Plaintiffs caused a cease and desist letter to be sent, and in response to plaintiff's demands an implicit promise not to file suit, defendant corrected the word church to hospital. Now plaintiffs complain anyway of defamation and have filed a defamation suit against defendant over the
Try to be a help channel, so I got another legal word for you guys to break down. It's called estoppel. The principle which precludes a person from asserting something contrary to what is implied by a previous action or statement of that person or by a previous pertinent judicial determination. Again, this is referring back to Pennsylvania. This is another one of those terms I brought up when I was over on Trisha's explaining all of this, on the grounds that this should be dismissed, in my opinion. So I just wanted to break that down for you, to tell you guys, what it means. Yeah. It's a judicial device whereby a court may prevent or stop a person from making assertions or from going back on their word. That comes into play because in the cease and desist, Granny was told that she was supposed to correct her statements about it not being a church and it being a hospital, even though I can see honestly how anyone would make that mistake because solely on the name. Okay. But she did what was asked of her and what was written on the paper for her to do that she did. They reneged on it by filing this lawsuit. You see what I'm saying? Yeah. Okay.
word church versus hospital in spite of the correction demanded. Don't forget, because I corrected that. Hey, nonsense.
Good morning.
Good morning. Let me add you to the screen. We're getting to the good stuff now.
Okay. I will absolutely help you read whatever you want me to. But if I all of a sudden just mute, it's because Hank's acting up because our pool guys are here. So,
Okay. Fancy with pool guys. All right.
well, he freaks out and they have a lot of work to do today because we had a hubbub the other night. So our pool is like a mud pit right now. So he's going to lose his mind.
No worries. Actually, let me
Can I address one comment?
yeah.
Missy, you're just understanding that I'm a saint. Girly, I've had saint tattooed on my hip for years. Catch up. It's always been saint nonsense.
Saint nonsense?
That's what she's calling me. I have no fucking clue. Oh, people just like to troll.
Give me one quick second.
I got that shit tattooed on me. Of course I am. It also says sinner too if you flip me up the other side. Cabana boys, yes. Good morning, everybody. Sorry, I come up and interrupt Jess. Saint nonsense. That sounds I can't. Oh, that's some shit. Yeah, I have an ambigram. That's actually truthful. No lie detected. Can we all get matching dark side devil tattoos, Lippy says?
Oh my goodness.
Oh yeah, over here, all of us that are against this frivolous litigation are called the dark side. All of us that don't agree with everything that Seth Rogers has ever said are the dark side. Yeah.
Law. We
For
did
record.
lack of personal jurisdiction because I do not believe Oklahoma has jurisdiction over me.
Correct.
We did a motion to dismiss lack of subject matter jurisdiction.
Yeah.
We also did res judicata, which basically means he's trying to argue the same exact thing he's arguing over here in PA. So he's basically trying to take the same complaint and just take it into a different court.
Okay.
Then we argued forum nonconvenience, and that basically what was I forget that one. Hold on.
Let me look it up.
Yeah, I can put in a quick Google. Forget what that one meant. Legal term, which translates from inconvenient forum, allowing a court to decline jurisdiction. Okay, so basically, like, again, jurisdiction. Then we also did estoppel. Estoppel is basically, they sent to C&D and said that they would not pursue litigation if I corrected the term from church to hospital, which I did.
Which you
But
did.
they filed anyway. So that's an estoppel. And then we also put in for a motion for summary judgment. And this is all argued here.
Okay.
So here's the facts of the case. On May 27, 2022, for an unknown reason, plaintiff Tony Mathis received a check from his mother-in-law for $30,000. A photocopy of this check becomes relevant, of course, of the facts of the case. Now, they called me Jennifer here, but they'll fix that. That's called a Scrivener's error. What's not a Scrivener's error is when you add a attorney as a plaintiff. That's not a Scrivener's error. So I reside in Delaware County, Pennsylvania, not to be confused with Delaware County, Oklahoma. I operate a YouTube channel called Granny's Watching, which is about true crime, issues of public controversy. On the channel, Jessica broadcasts information and opinion, both of her own and that of others. She states her own opinions, discusses facts she has learned, and often restates the opinion of others or facts obtained by others. Saying's articulate,
Such as
expressive
other
commentary has
creators.
earned and followed approximately 17,000 channel subscribers. However, the videos, shorts, live streams, and previously recorded live streams are available to non-subscribers as well. A few exclusive videos are only available to members who pay a small fee to watch the videos. It is fair to say that my commentary at times is vehement. Is that how you say that?
Yes.
Caustic and sometimes unpleasantly sharp per the description of such non-defamatory free speech found in New York Times. It is fair to say Jessica labors at a hot forge of free speech about matters of public controversy.
I just want to make everyone aware whenever she is talking about the New York Times, yes, she is talking about the New York Times. And the reason it is pertinent is because of a defamation lawsuit that they were involved in. So whenever she refers to them, that is who she's talking about. But she's specifically referring to the litigation that they were involved in. So it's noted that it's, the New York Times, but she's actually referring to the litigation. But yes, it is associated with the New York Times as the litigator. Okay, here we go.
This is the kind of hardy environment mentioned in New York Times where any sensitive, thin-skinned individual with easily ruffled feathers should best not voluntarily inject himself or be drawn into a particular public controversy, to closely paraphrase the New York Times holding. So it's basically saying that Tony admits that he came in to Sebastian's case and be Seth Rogers' spokesman because Seth Rogers was being attacked.
Well, on top of that, not only does he admit that, he says he's America's most hated man before you ever covered him. He states that he was taking arrows and people were, continuing to shoot at him and all of that. Hold on just a second.
Yeah, that does come in to mention further down.
Perfect.
Nonsense. I sent you an email a few days ago with links to BJ and Craig's TikTok.
Yes, these are true statements that they are talking about. Not only that, but I'd like to take it a step further, because even the people that Tony Mathis has surrounded himself with in another litigation were talking smack about him at one point, including allegedly with Brittany, who was one of the litigators that signed up against Granny's Watching in Pennsylvania. How does that happen?
4-hour live that I recorded. Lots of good bits you can use.
Thank you, Snazzy. Thank you for supporting Jess too, and thank you for sending. I will check. Sorry, guys. Okay.
My heart is with you, Pretty in Pink, catching up on 2 speed. For TTT, Smath, thank you. In the Pines, I'm the most hated man in America. May 2024. Facts.
May 5th, 2024.
Yep. Thank you, Snazzy Trinkets. And then Shadow says, aren't the land...
You guys, before we go any further, I have pinned Granny's Watching's link to this video in the chat. You guys go subscribe to her channel, support her in this and her going through this. Even if it's just a kind word, um, you know, helping keep her strong in all of this because honestly, she's she's fighting this battle and it's all done against her, but it affects each and every single one of us because they have drug other creators, they have drug channel commenters, subscribers, members, everyone into this. Everyone. They have drug everyone into this and drug everyone through the mud. And this woman is carrying a battle on her shoulders for all of us. So if you don't mind, go ahead and click her link. It's in the video description below as well. And go over there and give her a thumbs up, give her a shout out, tell her I sent you, and show her a little love. She's going through a lot fighting a battle that really affects us all. Okay.
Purchase check and the quit claim done years apart? Yes. Which is why I came out and told you all this is what they say about the quit deed, but I can't confirm it because the check's from, 2000 and something, 22.
122? Yeah.
Yeah. So, but that all gets argued further below. 127. One public controversy concerns. Do you want to read this part? Are you able to see it?
Yeah, give me 1 second. Let me stop moving around for a second so I can actually look at it. But yeah, I can. Okay. Got them to, okay, I think I can see it. Hold on. 127. One public controversy concerns the mysterious disappearance of a minor child named Sebastian Rogers in Tennessee. Thereafter, Sebastian, who went into his bedroom one night and was not there in the morning.
A three-part Providence.
It is undisputed the disappearance of Sebastian is the subject of intensive media scrutiny and public controversy. It is undisputed that on YouTube, more than a dozen channels have commentary on the mysterious disappearance of Sebastian. Defendant's YouTube channel is one of the many channels with such commentary. 128, the biological father of Sebastian, one Seth Rogers, hereinafter Seth, is not married to the mother of Sebastian. The mother is married to another man, the stepfather of Sebastian. Plaintiffs reserve the right to submit a supplemental brief on Seth and more details of this public controversy.
Yeah, a secondary brief to further, explain why Seth is of controversy.
Who Seth is. And
Exactly.
exactly what Seth has, because Seth is a piece of the Pennsylvania and Tony.
Exactly.
Very
Cash
good.
says, I'm the most hated man in the Karama community. Cash 2025. You stop that. You are not. We all know that somebody else has that title.
I like
Thank you,
that,
Angel
though,
Chip. It is funny.
because the secondary supplemental that could contain a lot of information if it needs to go that far.
Exactly. 129. Seth retained a self-described national spokesman who was plaintiff Tony Mathis. 2. Proclaimed Seth is innocent in the disappearance of Sebastian. Various individuals, including plaintiff Tony Mathis, formed a self-described green team with a stated intention to search for Sebastian and raise awareness about the disappearance of Sebastian. Fundraising was part of these efforts. Plaintiff reserves the right to submit a supplemental brief on members of the green team and more details of this public controversy. So when you talk about her in your public reputation, I think being associated with certain people may harm it further or more or before.
Absolutely.
That was something that come up. Everyone was talking about with Seth Rogers was the fact that he was, and again, this was not just Granny's watching. There were multiple creators that were calling out. Why was he having Tony Mathis after Tony Mathis especially did that with Caleb Harris's Facebook page about him being missing? He took it and made it a hate web page about Jonathan Lee Richards. So, there's that. And then he exposed himself on a live stream on TikTok as the spokesperson for Seth Rogers. Like, and then he was involved with that he admitted to with his family and the Ponzi schemes or whatever. Like, I don't understand, why people are so upset with the outcome of what they get when they align themselves with these kind of people, and then everybody wants to get Sue happy and join up and dogpile on Granny whenever it was some of those very same people, content creators, that were also talking about Tony Mathis like he was a dog. And they were mad that Seth was getting involved with him. It wasn't just Granny. Those live streams are recorded. They exist still. Even though that person has wiped their YouTube channel.
This part. Plaintiff Tony Mathis and members of the Green Team, to include Dwayne the Dog Chapman, a public figure known as Dog the Bounty Hunter, did not like the commentary defended Jessica, nor the commentary of another individual with, well, a TikTok channel.
And yes, no, y'all are not crazy. Dwayne Chapman, aka Dog the Bounty Hunter, did in fact take part and join in the frivolous litigation against this poor mother of two in Pennsylvania. Sure did. He sure did. That's already been anti-slapped. An anti-slap was granted on the litigation in Pennsylvania for Granny's watching. It's just in appeals for the third time. And I have a feeling this will be the third time in the Superior Court that the appeal gets struck down. And I wonder why. It reads like a clown wrote an application. Yeah, a job application. No kidding. Okay.
Stephanie, and alleged statements made on the respective YouTube channels were not defamatory. You want to take the next? We'll switch on and off.
Sure.
Oh, thank you, Croc.
On October 18, 2024, Tony Mathis and other members of the Green Team sued defendant Granny Barbecue and 50 does in the state of Pennsylvania. See Exhibit A, the Pennsylvania complaint. The complaint was described by Judge Kelly D. Eckel of the Court of Common Pleas of Delaware County, Pennsylvania, as a sprawling and at
I would never buy cannabis online.
comprehensible document. See Exhibit B, the Pennsylvania dismissal, page 3, last paragraph.
Yep. The complaint was also described by Judge Eckel as follows. The complaint does not seek damages for the alleged wrongful conduct. Rather, it seeks to preclude defendants from hosting their podcasts and to enjoin various forms of speech and or conduct. Emphasis added, Exhibit B, the Pennsylvania dismissal, page 4, middle of first paragraph.
133. In their defense against defamation, defendants cited 42 PA blah, 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 an anti-slap statute. On December 20th, 2024, defendant Barbecue filed a motion to dismiss under the statute. And on December 23rd, 2024, defendant Granny filed a motion to dismiss under the same statute. See discussion of the filings in Exhibit B, the Pennsylvania dismissal, page 1, first paragraph.
On March 26, 2025, plaintiffs filed an amended mercy motion for protective order and enjoined unauthorized recording, broadcasting, and doxing. Hereafter, plaintiffs' amended motion.
In said restraining order, protection order. Yes, protection order. They said that on the grounds, part of the grounds for them begging for the restraining order, protective order, excuse me, was that my husband on a business call in the background was me and another YouTube creator, Jay, who is completely innocent of anything. Let me tell you what. We were just a panel, all of us talking, my husband on a call in the background, waiting to hear any updates from court. And they said that my husband on a business call in the background was in fact us live streaming court somehow. I have no idea how we were supposed to stream said court because someone said that someone was streaming in court and the judge took all of the phones of everyone in the courtroom away. And allegedly that, my husband being on his business call was afterwards. But yeah, they have made bold-faced lies to continue to harass people. And Granny is the target of all of that. But it affects all of us. I'll let her continue.
Emphasis added. The plaintiff's amended motion is described in Exhibit C as consistent of 107 pages, 505 paragraphs, and 446 attached exhibits. Exhibit C, plaintiff's motion dismissed as mute, page 3, last paragraph. The plaintiff's amended motion is not attached as an exhibit due to its voluminous nature, plus the fact Exhibit C dispenses with the plaintiff's amended motion for court and a scathingly worded court order at that. Number 6, defendant believes her case was the first case in Pennsylvania to raise as a defense under anti-SLAPP statute. The statute became law in July of 2024, and the case against defendants was filed in October of 2024.
Huh. Well, you don't just believe it is the first anti-SLAPP, isn't it?
Yeah.
That's what I thought. Okay. 135 on April 8th, 2025, plaintiffs Tony and Dana Mathis transferred property they owned in Delaware County, Oklahoma to their in-laws in a quit claim deed listing $1 good and valuable consideration. See attached Exhibit F, the $1 quit claim deed.
8 days after the quitclaim deed was created on April 17, 2025, the Court of Common Pleas of Delaware County, Pennsylvania, issued an order granting defendants motions for dismissal and requiring plaintiffs to pay defendants attorney fees and costs under the Pennsylvania anti-SLAPP statute, which is Exhibit B, the Pennsylvania dismissal.
It is in 137. It is the sincere belief of defendant Granny that plaintiffs Tony Mathis and Dana Mathis anticipated the Pennsylvania trial court was about to order plaintiff Tony Mathis to pay lawyers' fees. And for this reason, plaintiff Tony Mathis transferred some or all of his Delaware County.
I agree with Granny. I think the exact same thing. Sure do. Sure do. That check from 2022 might have had nothing to do with the fact that that house was sold as a quitclaim in 2025, a week before the ruling for the lawsuit came down. I sure do. I agree with Granny. I do.
County, Oklahoma real property assets out of his name and into the name of his in-laws.
And on that same date, the same court issued an order denying plaintiffs' amended emergency motion for protective order and to enjoin unauthorized recording, broadcasting, and doxing. Exhibit C, plaintiff's motion to dismiss as mute.
And that one got tossed too. That was the same exact date, Jess?
Yes.
I forgot about that.
Mm-hmm.
Oh, okay. 139, in response to the dismissal on May 12, 2025, plaintiffs filed an appeal in the Superior Court of Pennsylvania Eastern District. See Exhibit B, the Pennsylvania dismissal.
On May 13, 2025, plaintiffs' counsel in Oklahoma sent a cease and desist letter with 2 attachments. See Exhibit G, the cease and desist letter, hereinafter the C&D. While the C&D was being written, the appeal in Pennsylvania was still pending and is pending to this day, seeking inter alia a gag order to prevent defendant Sang from broadcasting.
Implicit in the C&D is a promise that if defendant Granny will issue corrections, defendant Granny will not be sued over the statements.
But on May 20, 2025, having carefully read the C&D and reviewed its attachments, defendant Jessica concluded the word church in her previous utterance was indeed incorrect. The church was, in fact, a hospital with a churchy sounding name. Therefore,
see, I thought so too. The hospital had a churchy sounding name. I'm sorry. Hang me up to dry if need be, you guys. But I really think I agree. It had a churchy sounding name. I mean, come on.
Sang diligently broadcast her correction as follows. I mean, it wasn't a church that sued Tony. It was a hospital. This corrected statement was made in the course of a YouTube broadcast with the title Stupid Statement by Seth Rogers. Sebastian Rogers' discussion have stopped, but why? The corrected statement was made as a direct result of the cease and desist letter, Exhibit G, which
and this is where estoppel comes into play. Because Granny adhered and did what the cease and desist requested, and the cease and desist said, do this or else you're going to get sued. Granny did it, and she still got sued. Estoppel. It's where they renege on the state, what they said they're going to do versus what they do.
Implicitly promised that if Sang issued a correction, Sang would not be sued for defamation over the matter corrected.
Yes. The cease and desist letter did not include sufficient information to prove to defendant Granny that she had made any error in regard to a dubious property transaction by plaintiff Tony Mathis. Indeed, the image of a check the confusing, seemingly irrelevant date of May 17th, 2022 only reinforced defendant Granny's belief that the dollar property transaction in question was an attempt by plaintiff Tony Mathis to escape the Pennsylvania judgment for lawyers' fees and costs, and that some kind of fraud was involved.
It would be
on May
too.
21st, 2025, there was a notice of appeal by plaintiffs in the Pennsylvania case. On June 30th, 2025, defendant Sang filed an application to quash appeal. On July 10th, 2025, plaintiffs filed an application of extension of time to file, which was granted that same day.
On July 22nd, 2025,
Now, if you're paying attention to what's going on right now, each one of these instances proves that this is exactly a SLAPP lawsuit, that these are SLAPP lawsuits. Okay. It's giving you all of the reasons why there are anti-slaps, why states have established anti-slaps. Everything that this motion to dismiss is laying out that happened in Pennsylvania is why Granny and Barbecue were granted anti-slap in in the litigation.
Their appeal to seeking a gag order, prevent defendant Granny from broadcasting was still pending in Pennsylvania, plaintiffs Tony Mathis and his wife Dana Mathis filed their petition in Delaware County, Oklahoma District Court, not to be confused with Delaware County, Pennsylvania.
On August 1st, despite the extension, the Superior Court of Pennsylvania entered a per curiam order granting the defendant Stang's motion to quash for failure to file a docket and statement.
On August 5th, 2025, in the Superior Court of Pennsylvania, Eastern District, plaintiffs filed an application to reinstate appeal, which is Exhibit D, the Pennsylvania appeal from dismissal, pleading inter alia bereavement leave.
On that same date, August 5th, plaintiffs were served their petition filed in Delaware County, Oklahoma, on Jessica at her residence in the state of Pennsylvania. On the same date.
On August 22nd, 2025, the appeal in Pennsylvania was reinstated. See Exhibit E, Penn Appeal Docket Sheet.
Yep. Authorities support a motion to dismiss a legal action based on a party's exercise of rights under the Oklahoma Citizen Participation Act. Invoking Oklahoma, we'll call it the SLAP, and filing a motion to dismiss under the SLAP within 60 days invokes the legal rights associated with this SLAP, including all discovery in the legal action shall be suspended as follows.
Oh, sorry. A, if a legal action is based on, relates to, or is in response to a party's exercise of the right of free speech, right to petition, or right of association, that party may file a motion to dismiss the legal action.
B,
okay, go ahead.
A motion to dismiss a legal action under this section shall be filed no later than 60 days after the date of service of the legal action. The court may extend the time to file a motion under this section on a showing of good cause.
C, except as provided in Section 6 of the Oklahoma Citizens Participation Act, on the filing of a motion under subsection A of this section, all discovery in the legal action shall be suspended until the court has ruled on the motion to dismiss.
See Exhibit D, 151. The case of Roberts v. Bush in 2023 is the Oklahoma, is applicable here and is attached as Exhibit H. In Roberts, the Oklahoma Court of Civil Appeals, Division 3, reviewed de novo the issue of whether the trial court properly granted a motion to dismiss pursuant to the Oklahoma Participation Act. Roberts argued to the trial court that Mrs. Bush's reliance on the Oklahoma Participation Act was misplaced as it only provides protection for speech that is not prohibited by law. He claimed that slander is actionable per se if it falls within the first 4 sections of 12 OS.
152. Oh, go ahead.
No, you can go ahead.
In applying the OCPA, the Court of Appeals laid out a 2-part test as follows. Under 1434, a party seeking dismissal of an action under the OCPA must demonstrate by preponderance of evidence that the action is based on the party's exercise of the right of free speech. Once the first element is satisfied under 1434, the burden shifts to the non-movement to establish.
Basically, the person that did it filed.
Yeah. To establish by clear and specific evidence a prima facie case for each essential element of the claim in question. A prima facie case is defined as such as will suffice until contradicted and overcome by other evidence. Kimball versus blah, blah, blah. The term clear and specific evidence is presumptively in harmony with the established standard for prima facie case. The OCPA requires a court to consider the pleadings and supporting and opposing affidavits stating the facts on which the liability or defense is based. 1435. Therefore, a petition, if filed to the minimum standard.
Help Channel, breaking in. Prima facie is based on the first impression accepted as correct until proven otherwise. Prima facie. Okay. Just thought I'd, give you guys a heads up on what these big words mean. I know I had to use a dictionary and a thesaurus to look half of this up, so I did the work for you.
If pled, sorry, look at me over here. Therefore, a petition, if pled to the minimum standard of notice pleading, may not provide sufficient, clear, and specific evidence for purposes of the OCPA.
He noted that Roberts involved a public official who was, in summary, complaining that old information from his out-of-state divorce case, where Roberts' spouse had called Roberts abusive, was being used in a defamatory way by his opponent. The court applied the New York Times v. Sullivan standard to the plaintiff and Roberts as follows. Because Mr. Roberts is a public figure, as is Tony, he must overcome a high burden of proof to maintain a claim for slander because the standards set forth in New York Times v. Sullivan are applicable. Miss Coffee v. Oklahoma Pub, The right to free speech is protected by the First Amendment to the United States Constitution. And New York Times, the court noted the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. ID 2. In order to prevail on his slander claim, Mr. Roberts must show that the defamatory falsehood was made with actual malice. The New York Times court held that the Constitution demanded that malice be shown with convincing clarity. Actual malice requires evidence.
Convincing clarity. Not just because you think that person did it because they're a meanie. That don't cut it in a court of law, you guys. No, it sure don't.
That Ms. Bush acted with knowledge that her statements were false or with reckless disregard of whether they were false or not. Yates versus Gannett, the actual malice test is subjective. Looper versus Black, proof of guilty knowledge prior to publication is required to demonstrate that the First Amendment immunity does not apply. In Roberts, the court applied the holding of Crimble, wherein a petition, if pled to the minimum standard of notice pleading, may not provide sufficient clear and specific evidence for purposes of the OCPA. In paragraph 16 and 19, with a footnote of 7, the court said Mr. Roberts had failed to provide any affidavits or evidence in an attempt to establish how Ms. Bush's conduct constituted actual malice in response to the motion to dismiss. The appellate court record demonstrates that the petition filed by Mr. Roberts was not verified. Mr. Roberts also did not provide any affidavits or evidence in an attempt to establish how Ms. Bush's conduct constituted actual malice in response to the motion to dismiss. While simple examination of the limited factual record available from the judicial proceedings in Tennessee shows that the press release presented the facts from the Tennessee proceedings, the paragraphs in Roberts skip from 1619 for unknown reason. The press release presented the facts from the Tennessee proceedings in an exact and arguable hyperbolic manner. The record does not demonstrate that the allegations made in the press release were false. For purposes of meeting the standard of malice under New York Times standard, Mr. Roberts was obligated to present facts to demonstrate that the claim made by Ms. Bush in the press release were false or reckless. The record here only contains mere allegations of falsity or recklessness. Without more, Mr. Roberts was deficient in his duty to establish a prima facie case for slander. We therefore find that Mr. Robert did not satisfy his burden under 12 OS 1434 to establish by clear and specific evidence a prima facie case for each essential element of the claim in question. Accordingly, the order granting motion to dismiss is affirmed. The standard in New York Times is found at page 253 of New York Times, last paragraph, and page 254, first full paragraph as follows.
Sorry, Jess.
No, you're fine. I hear the background.
Kenzie and Hanker.
Happy birthday to Real Kels. Absolutely, I am, Lucia.
It was her birthday yesterday.
Happy birthday. Well, belated, but happy birthday.
We've had a lot of birthdays around lately. There's a lot of August birthdays.
Yeah, there is. Absolutely.
Okay, you want me to do the inquiry? No, did you just read that one?
I didn't read this, no.
Or injury. Sorry. Injury to official reputation affords no more warrant for repressing speech that would otherwise be free than does factual error. Where judicial officers are involved, this court has held that concern for the dignity and reputation of the courts does not justify the punishment as a criminal contempt of criticism of the judge or his decision. Bridges versus California.
I think we're reading too fast.
Are we?
Yeah, we're like speed reading here.
We're all like, let's get through it.
Trying to get through it.
Let me slow it down. Bridges versus California, 252. This is true even though the utterance contains half-truths and misinformation. Pennekamp versus Florida, 328, blah, blah, blah. Such repression. Why can I not speak? Repression can be justified, if at all, only by a clear and present danger of obstruction of justice. See also Craig versus Harney, Wood versus Georgia. If judges are to be treated as men of fortitude, able to thrive in a hardy climate.
What if you can create your own website?
Craig versus Harney. Surely the same must be true of other government officials, such as elected city commissioners. 14. Criticism of their official conduct does not lose its constitutional protection merely because it is effective criticism and hence diminishes their official reputations. Emphasis added.
So basically, just because I'm criticizing your position as a national spokesman, to emphasize and underline the legal point, when criticizing official conduct, even an utterance containing half-truths and misinformation enjoys constitutional protection under New York Times.
Even an utterance of half-truths and misinformation enjoys constitutional protection under New York Times. Such criticism containing half-truths and misinformation is allowed, even when the half truths and misinformation diminish official reputation. In other words, it doesn't matter how high and mighty you think you are, we are all subject to the same freedoms under the Constitution. Just like you can talk smack, we can talk smack. But if you're a public official, that means that you're entitled to even more scrutiny. You're entitled to even more, what's the word I'm looking for here? Scrutiny's good enough. Yeah, you're just entitled to more scrutiny that comes with putting yourself in the official public eye. And granted, if it is truly dangerous to a person's reputation or something like that, okay, let's say it is. Guess what? We're still entitled to that scrutiny. We are. When we put ourselves out in the public view, if we say something someone doesn't like, guess what? We put ourselves out there. People didn't like what we had to say. That's our fault. We put ourselves out there with our opinion for it to be heard. With everything about us. When you make yourself a public official or a public figure in any way, you are no longer a private citizen. Yeah. If someone says something that could damage your reputation, well, you're going to have to prove that it was with malice, that there was absolutely no truth to it. Both. That it was willful and intentional. And then you're going to have to prove those very real damages. But you're still entitled to the same half truths and misinformation that all of us are. Sorry, but you are. We're all, none of us are above it, but we're all entitled to it.
Such criticism containing half-truths and misinformation is allowed even when the half-truths and misinformation diminish official reputations. Public officials in public arenas are expected to be men of fortitude, able to thrive in a hardy climate, instead of being thin-skinned and crying defamation when a hurtful half-truth is uttered, or even when errant information is sincerely published. Example, unintentional misinformation.
157. Roberts and New York Times both involve public officials, but the case of Gertz versus Robert Welsh Incorporated made clear that in regard to the legal standard applied to defamation and public officials allowing half-truths and misinformation, a plaintiff complaining of defamation could be a public figure or a limited purpose public figure. Gertz, as cited by the Supreme Court of Oklahoma in the case of Martin versus Griffin Television Incorporated, explained at Paragraph 10, the test to determine whether an individual is a public figure or a public figure for a limited range of issues, commonly referred to as limited purpose public figure. Martin is attached as Exhibit 1.
So paragraph 10, basic to Gertz and to the present case is a determination as to whether the defamatory plaintiff is a private individual or a public official or figure. The Gertz opinion aids in the determination, saying that designation may rest on either of two alternative bases. In some instances, an individual may achieve such persuasive fame or notoriety.
Tony Mathis, you come out here and were the self-proclaimed spokesperson for Seth Rogers. You went on national television and said you were the spokesperson for Sebastian Rogers. You did press interviews as the spokesperson for Seth Rogers. Every chance you got to be on camera with Seth, you were, as a quote national spokesperson. You made yourself a public figure. You willingly put yourself into that public spot. Okay.
That he becomes a public figure for all purposes and all contexts. More commonly, an individual voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. In either case, such person assumes special prominence in the resolution of public questions. So even though this is a case of a nationally known case of a missing child, therefore it is absolutely a matter of public concern, making Tony by standard at minimum limited purpose public figure.
Absolutely, it is.
Well, absolutely. I would think that would be easy for the courts to see because he has been on all these media and introduces himself as such too. So
Right.
that will give great.
And then it says, we will not lightly assume that his citizens' participation, community, and professional affairs rendered him a public figure for all purposes, absent clear evidence of general fame or notoriety in the community, and pervasive involvement in affairs of society. An individual should not be deemed a public personality for all aspects of his life. It's preferable to reduce the public figure question to a more meaningful context by looking to the nature and extent of an individual's participation in the.
But yet Tony has not come out and said he was no longer a national spokesperson. So there's that.
particular controversy giving rise to the defamation.
158. Roberts uses a different wording in its holding than half-truths and misinformation for the New York Times holding. Instead, Roberts holds speech that is inexact and hyperbolic is allowed against a public official without being defamation. It therefore would appear that in Oklahoma, a defendant in a defamation case has the benefit of both New York Times and Roberts, and so may engage in speech against a public official, public figure, or a limited purpose public figure that is half-truth, misinformation, inexact, or hyperbolic per Roberts without such speech being defamation. That's very interesting. I
Yeah.
want to look at that entire case actually.
Yeah. This is due to the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, per New York Times. Also applicable is 12 OS 1438 as follows.
A, if the court orders dismissal of a legal action under the Oklahoma Citizens Participation Act, the court shall award the moving party 1, court costs, reasonable attorney's fees, and other expenses incurred in defending against the legal action as justice and equity may require, and 2, sanctions against the party who brought the legal action as the court determines sufficient to deter the party who brought the legal action from bringing similar cases described in the Oklahoma Citizens Participation Act. And B, if the court finds that a motion to dismiss filed under the Oklahoma Citizens Participation Act is frivolous or solely intended to delay, the court may award court costs and reasonable attorney's fees to the responding party. Very
Oh.
interesting.
So here's the argument why my case is applicable to the Citizens Participation Act. The petition filed by plaintiffs in Delaware County, Oklahoma, evidences the same torturous legal logic as the suit which was dismissed in Delaware County, Pennsylvania, accompanied by several caustic and unpleasantly sharp criticisms from the Pennsylvania court in the dismissal. And then it says Oklahoma Participation Act is applicable due to defendants' exercise of free speech.
Per Roberts, on paragraph 12 under 1434, a party seeking dismissal of an action under the OCPA must demonstrate by a preponderance of the evidence that the action is based on the party's exercise of the right of free speech.
Here, it is not in dispute the case involves free speech. The only dispute is whether certain free speech utterances were defamation. Plaintiffs admit that the action is based on the party's exercise of the right of free speech in their complaint at paragraph 18. Complainant defendant owns and operates a YouTube channel called Granny's Watching, which has almost 17,000 subscribers. The subscribers as of the date of this filing actually exceed 17,000. In paragraph 18, plaintiffs complained the defendant authored, edited, and published. On March 26, 2025, plaintiff Tony Mathis sought a protective order to keep defendant saying ad al from broadcasting. Exhibit B, page 1, paragraph 1. All of the utterances complained of as allegedly defamatory were exercises of free speech on widely accessible public YouTube forums in the course of discussion about a public controversy.
Wendy came in chat, and I just want to mention what she said here too. She said, keep in mind that by virtue of having Dog the Bounty Hunter at their side with this case, it also lends further verification of public figure in the eyes of the public, one could argue.
Yeah, that's why he was mentioned up
Bing
above.
bong.
Yeah,
Yep.
that's great. This is great. I love it. Okay, the matter in the complaint is not only by a preponderance of the evidence based on a party's exercise of free speech, but easily meets a beyond reasonable doubt standard without being required to meet
The higher
the
standard.
higher standard. There's
Which
it.
is footnote number 8. Let's go to that. Arguably, any complaint of defamation and slander in Oklahoma should automatically be a prima facie case to apply the OCPA without the need to present evidence that defendant was exercising free speech. So plaintiff Tony Mathis is a public figure, or alternatively, a limited purpose public figure. In arguing a case for defamation, it is first necessary to determine whether the plaintiff involved is a private citizen, a public figure, or a limited purpose public figure to determine whether the higher standard of New York Times, Gertz, Roberts, Martin, and the progeny must be applied. It is
is-
okay.
What is this? Res
Res judicata.
judicata. It is arguably res judicata that Tony Mathis is a public figure or a limited purpose public figure. See Exhibit B, the Pennsylvania dismissal, page 3, bottom of the 3rd paragraph, wherein the court found all the plaintiffs in the Pennsylvania complaint, to include plaintiff Tony Mathis, were all either a media company, a television personality, or various YouTube broadcasters and or podcasters and or online social media personalities. The court did not need to state, for purposes of its dismissal of the sprawling and at times incomprehensible document, that plaintiff Tony Mathis is a public figure or limited purpose public figure. The language in the order can only describe public figures like plaintiff Dwayne Dog Chapman or limited purpose public figures.
And here, plaintiff Tony Mathis actually claims to be a public figure, stating he is the national spokesperson for Mr. Rogers, Seth, who is the father of Sebastian. Refer to paragraph 4 above. The mysterious disappearance of Sebastian is a public controversy and an issue of public concern. Defendant argues that since plaintiff Tony Mathis claims to be a public figure, plaintiff Tony Mathis must accept the higher legal standard for defamation that comes with being a public figure.
Well.
I completely agree with the attorney here. Completely. He did a very good job writing this.
Alternately, I can't see. I'm staring into the sun and I'm like, wait.
It is hard to read it.
Plaintiff Tony Mathis is a public figure for a limited range of issues per Martin applying Gertz. This often referred to in shorthand as a limited purpose public figure, a term defendant will herein adopt. The definition of a limited purpose public figure per Gertz, quoted in Martin, paragraph 10, is an individual who voluntarily in
Well, my goodness. Come on. There we go.
particular public controversy. Well.
Mm-hmm. Plaintiff Tony Mathis admits he has voluntarily injected himself into a particular public controversy at paragraph 16 of his complaint as follows. Despite the emotional financial sacrifice he knew it would entail, Mr. Mathis began volunteering as Seth Rogers' spokesman and advocate in May of 2024.
Therefore, should plaintiff Tony Mathis be able to overcome the many other flaws in his complaint to include jurisdiction, plaintiff Tony Mathis is either a public figure or a limited purpose public figure and must therefore prove actual malice to sustain his claims of defamation against defendant Graney.
Plaintiff Dana Mathis is a limited purpose public figure. Plaintiff Dana Mathis is the wife of plaintiff Tony Mathis. The name Dana Mathis appears in the caption of the case. There is also mention of the word wife in paragraph 27, wherein defendant is quoted discussing a suspicious land transaction by plaintiffs just prior to an order in Pennsylvania finding plaintiff Tony Mathis, as well as the other plaintiffs, liable for attorney fees. Otherwise, Dana Mathis appears nowhere in the case amid the many allegations by plaintiff Tony Mathis.
The failure of plaintiff Dana Mathis to meet the Crimble standard is argued further below. Plaintiff Dana Mathis is a limited purpose public figure because, due to the actions of her husband, Dana Mathis has been drawn into a particular public controversy per Gertz, not Girth, quoted in Martin at paragraph 10.
None of the alleged statements were defamatory under New York Times and Gertz and Roberts. Under New York Times, a statement made about a public figure may be half-truths or misinformation, yet be non-defamatory. Under Roberts, applying Gertz to a limited public figure, limited purpose public figure, a statement may be inexact or hyperbolic and yet be non-defamatory. Let us examine each of the statements alleged to be defamatory applying to the New York Times and Roberts standards.
Hyperbolic.
Having correctly stated in paragraph 26 where the statements were made, plaintiffs list the alleged defamatory statements in paragraph 27 as follows. 27. In that video, defendant made the following false and defamatory statements. A, quote, have any of you ever robbed a church? Question. Well, Mr. Tony Mathis has. B, Tony was sued by a church for a large sum of money. C, Tony and his wife certainly have been sued by a church.
Paragraph 27 must be weighed against paragraph 20 through 23, where plaintiffs admit plaintiff Tony Mathis was sued by Missouri Baptist Hospital, never paid a large hospital
Here
bill,
comes the
but the lawsuit was
bombshell.
dismissed.
I love this part.
This factual background is useful. Missouri Baptist Sullivan Hospital, the proper name for the facility, publishes its hospital history at, you can go to the website. The hospital was once a community hospital, which was eventually absorbed into the BJC healthcare system, which stands for Barnes Jewish Christian Healthcare. In its western region, BJC is known as St. Luke's Health System.
Well. Despite being associated with the labels of Baptist, Jewish, Christian, and St. Luke's, the hospital in Sullivan, Missouri, and the BJC system serves all creeds. It is accurate to say Missouri Baptist Sullivan Hospital is a secular hospital with a churchy sounding name. which is affiliated with other entities that have churchy sounding names. This churchy sounding hospital is that entity that, by plaintiff Tony Mathis' admission, sued him for an unpaid hospital bill.
Another piece of information is relevant. Defendant Jessica is not the original author of Rob the Church. The phrase defrauded a church was used by a YouTuber on a channel called JLR Investigates. It appears the name of JLR or one of his internet.
Yes, it was. As a matter of fact, that's where all of this started. And I'm not knocking on JLR. Not at all. Not at all. But that is where this all originated from. You see, but Nick Has a Fat Sue used to be friends with JLR. So naturally, they're not going to file a lawsuit against JLR for something he said against Tony Mathis, right? But they're going to go after Granny for what was said by who used to be one of their own constituents, if not, might still be one of their own constituents. Make it make sense.
Aliases as Jonathan. On August 24th, 2025, JLR publishes on his YouTube channel, Sebastian Rogers, Seth's Fault, Tennessee Arrest. JLR then promoted the video on his Facebook as follows, also attached as Exhibit J, JLR's Facebook post. Driving to church discussing the Sebastian Rogers case. Did you know Seth Rogers spokesman Tony Mathis and his wife Dana were one?
Also, just a shout out, Mr. Lesniak, if you're paying attention, this is how you attach exhibits in an appropriate motion. Take notes.
Was sued in Joplin, Missouri for defrauding a church. In another post that same day, JLR went even further in a statement about Tony Mathis as follows. Tony Mathis is a visual scam artist criminal who has been sued over 25 times in Oklahoma and Missouri for fraud and breach of contract. Even a church and school sued him and his wife, Dana Mathis. He has numerous bankruptcies, liens, and judgments against him, failed businesses. He has warrants for his arrest in the past.
The fact defendant Granny was merely repeating an allegation she sincerely believed and was not the original author of the allegation. Under New York Times, both for lack of actual malice and for misinformation, which does not meet the standard of defamation against a public figure, nor under Gertz, as cited by Rogers, a limited purpose figure.
It is also relevant that on May 20th, 2025, defendant Jessica issued a corrective statement regarding the word church instead of the word hospital. Defendant Sang did this upon the implicit promise of the C&D that if she issued a correction, defendant Sang would not be sued. Defendant Sang issued a correction about the one word she believed needed correction, hospital versus church.
This is where estoppel comes in.
Let us examine each of the statements in turn and apply the New York Times and Roberts standards wherein the statements may be half-truth, misinformation, inexact, or hyperbolic, yet not be defamatory. In one instance, which is complained of in plaintiff's paragraph 28, the legal standard need not be applied because there is no evidence defendant Granny ever made the statement.
In regard to the statement, have any of you ever robbed a church? Well, Mr. Tony Mathis has. The statement can be fairly described by any one of the allowed standards as follows. A, half-truth. The word robbed is a half-truth of failed to pay despite being sued. The word church is a half-truth of a hospital, which is churchy sounding name. However, the word church is irrelevant because on May 20th, 2025, prodded by the C&D and his implicit promise, defendant Sang issued a correction of the word church to the word hospital.
Misinformation. In the context of New York Times, this term means the speaker or the writer of the information did not know the information was false and therefore does not meet an actual malice standard for defamation of a public figure per New York Times or per Gertz as applied in Roberts, a limited purpose public figure. Here, most importantly,
Correct.
defendant Granny was repeating information from another channel, see Exhibit J, and sincerely believed the information to be true. This puts defendant Granny squarely under the New York Times misinformation standard, and the statement cannot be defamatory against a public figure or a limited purpose public figure.
Also, defendant Sang was unaware of a churchy sounding hospital of Baptist, and the name does not have an affiliation with a Baptist church. This is not actual malice, but mere mistake, and hardly a careless mistake at that. Who would not, upon hearing a hospital has Baptist in his name, fail to think the hospital is somehow an entity of some Baptist church?
Further, no actual malice is present regarding the word church instead of hospital. This is shown by the fact that defendant Granny issued a corrective statement in regard to hospital instead of church on May 20th, 2025. There cannot be actual malice over an admitted mistake, a mistake which was not even that of defendant Granny to begin with, but another YouTube channel. But defendant Granny was using information from another source that plaintiff Tony Mathis defrauded, and defendant Granny used the words robbed, which is a word with closely similar meaning.
It is also misinformation to say robbed instead of failed to pay a large debt even after being sued. The sincere misunderstanding about the exact specifics of the hospital lawsuit situation puts the word robbed squarely under New York Times misinformation standard.
Inexact, the word robbed is an inexact way to say money was owed, but the person that owed the money walked away from the debt, even after being sued. The word church is an inexact way to say a hospital with a churchy sounding name. In any case, church is irrelevant because of the correction, which was issued based on the implicit promise of the cease and desist letter.
How do you say this again?
Hyperbole.
Hyperbole?
When you ask me, now I can't say it.
I know.
Hyperbolic, hyperbole.
This word means an
Hyperbole.
exaggeration. Here, the word robbed is an exaggeration of the circumstance where money was owed, but the person that owed the money walked away from the debt, even after being sued. Here, the word church is also hyperbole because the actual entity was a hospital with a churchy sounding name. Any hyperbole was unintentional because defendant sang believed church in the moment she said church. Unintentionally hyperbole, however, it is still hyperbole.
You guys, what they mean is hyperbole. It's just hard to read as a word. I get it.
These are all reasons why it's not defamatory.
Hyperbole. Hyperbole? Is that
Whatever it
hyperbole? See, there's hyperbole. Yeah.
Whatever.
We're getting through it, okay? Just let us go.
Hyperbole.
I can
Hyper.
Hey, they're doing great.
Hyperbole.
They're doing
Whatever.
great.
You guys know the dang word.
It's
Oh,
not
I've already
girth either,
butchered
it's
half of
girth,
this.
you guys. Behave in the chat. Have you watched this chat? They're over here like thinking this is only freaking filings or some shit. They're acting a fool in the chat. In regard to the statement, Tony was sued by a church for a large sum of money. The words sued and a large sum of money are not in dispute. In paragraphs 20 through 23, plaintiffs admit plaintiff Tony Mathis was sued over a hospital bill, and the amount was more than plaintiff Mathis could pay, therefore a subjectively large sum of money. And the hospital eventually dropped the lawsuit.
Therefore, the only allegation of the sentence being defamatory is the word church. It is relevant that on May 20th, defendant sang issue a corrective statement regarding the word church versus the word hospital.
Even so, let us examine the word church and apply the New York Times and Robert standards wherein statements may be half-truth, misinformation, inexact, hyperbolic, yet not be defamatory. Half-truth here. Church is a half-truth of hospital with a churchy sounding name and affiliations that are also churchy sounding. The half-truth was unintentional. Defendant Graney sincerely believed a church was involved. However, an unintentional half-truth is still a half-truth.
Misinformation. Here, the sentence is mostly true, but the word church is misinformation, a tiny inaccuracy. It turns out Missouri Baptist Sullivan Hospital is not affiliated with the Baptist Church. Who knew? Not defendant Sang, who therefore does not meet the actual malice standard. Defendant Sang was
And I get it. I totally get it. JLR put it out that it was a church. I mean, it has Baptist in the name. I'm from the South. You give me a piece of paper with something written Baptist on it or Methodist or anything like that, and unless I see the word hospital, I'm going to assume you're talking about a church. I just am. I mean, granted, I am from the Bible Belt, what they call the Bible Belt, okay? But still, I would assume that if something, just Arkansas Methodist, you'd think that would be like the Arkansas Methodist Church, right? I mean, it's I can see where the mistake was made, but what's further is the cease and desist was sent and Granny corrected it, which falls under estoppel. Estoppel, listen to me. Estoppel. It falls under estoppel. Okay? It does. And the fact that she corrected it, I mean, it's still, yeah, the attorney has done a brilliant job writing this.
information from another YouTube channel promoted on YouTube. Unknown to defendant Sang, the information was not strictly accurate in the original source, and therefore defendant Sang falls squarely under New York Times definition of misinformation, which cannot be defamation against a public figure, nor under Gerst, as cited by Rogers, a limited purpose public figure.
Further, on May 20th, 2025, prodded by the C&D in its implicit promises, defendant Graney issued a corrective statement regarding the word church versus the word hospital. It is inexact to say church instead of the more precise term, a hospital with the name of a major Christian denomination, oh my gosh, and affiliations with other churchy sounding entities, but surprisingly, no actual church affiliation. The inexact nature of the statement was unintentional. Defendant Graney thought a church was involved, but inexact is still inexact and falls under the Robert standard. Hyperbole.
Yeah, there you go. You read this one.
Hyperbole. It is hyperbole to say church instead of a hospital with the name of a major Christian denomination, and affiliations with other churchy sounding entities, but surprisingly, no actual church affiliation. The hyperbole was unintentional. Defendant Granny sincerely thought a church was involved, but unintentional hyperbole is still hyperbole and falls under the Roberts standard.
In regard to the statement, Tony and his wife certainly have, and then parentheses, been sued by a church. I mean, they're adding that part, but whatever. Let us apply the New York Times and Roberts standards to the utterance Tony and his wife certainly have. It is relevant that on May 20th, prodded by the C&D, defendant Sang issued a correction of the word church to the word hospital. Church is a half-truth as argued above. In fact, plaintiff Tony Mathis and his wife, plaintiff Dana Mathis, were sued by a hospital with a churchy sounding name and the churchy sounding affiliations. The half-truth was unintentional. Defendant sincerely believed the church was involved instead of a hospital, but an accidental half-truth is still a half-truth. Did we just read all of this?
Yeah, they're repetitive. To break it down, it looks like. I think we can skip on to 190.
In their complaint at paragraph 28, plaintiffs complain as follows. Defendant also made statements during the live broadcast falsely accusing Mr. Mathis of enlisting other social media accounts to dox the defendant. Here, plaintiffs have not provided any proof such a statement was ever made by defendant. The claim in paragraph 28 therefore falls short on the basis of Crimble, which imposes a higher standard than notice pleading under the OCPA.
Yeah, you have to actually prove your point in a lawsuit. I mean, that's just, you have to. It's not up to the defendants to prove your case for you. You have to provide the documentation. You have to provide the attachments that go on the lawsuit. What are they called? Exhibits. Okay. And you have to prove your point. But what this is saying now is you have to meet a higher burden of proof, which is malice if you're a public figure, to prove that it's defamatory. And yeah, what Tony is claiming does not rise to the standards. I agree, in my opinion.
192. In their complaint in paragraph 29, plaintiffs next complain of statements made on April 23rd, 2025, which use the word church in association with the Missouri Baptist Sullivan Hospital lawsuit, and plaintiffs have reproduced a copy of the writing in question. The church statement complained of is, quote, "Were you not sued in Joplin, Missouri for defrauding a church?" End quote.
Here, the purported statement is not a statement. The purported statement is a question with a question mark after it. Because the words at issue are a question, not a statement, the words at issue cannot be defamation. Yeah, I literally wrote, "Were you not sued in Joplin, Missouri for," and they try to misrepresent that, but that's okay.
At paragraph 30 of their complaint, plaintiffs have deceptively edited to remove question marks. The first sentence actually read as follows, quote, "Did Tony Mathis and his wife commit fraud?" Question mark, end quote. Because
exclamation point, question mark.
There is an exclamation in there too, isn't there?
Yep.
Because the words at issue are a question, not a statement, the words at issue cannot be defamation and are not libel per se.
At paragraph 31, plaintiff complains of a video thumbnail image with the words fraud alert. Plaintiff complains the title alone constitutes libel per se. However, the thumbnail image cannot be removed, detached, considered apart from its actual title, which is the question. Did Tony Mathis and his wife commit fraud? Because the thumbnail is only an illustration for a title, which is a question, the thumbnail cannot be libel per se.
Plaintiffs further.
A question cannot be libel per se either. A question cannot be held. Look, a question is not a statement. It's not saying something as a fact. It's questioning. It's asking. It's not the same thing as making a statement. I don't think you can actually sue someone and hold them liable in any way for asking a question. This is, we're in America. We're America, okay? Okay.
Further complaint in paragraph 31 of the following statements purportedly made by defendant Granny. A, what Tony is doing is called fraudulent conveyance, right? Question mark, of course. And that's also known as a fraudulent transfer. So it is a transfer or property or assets by a debtor to a third party to hinder, delay, or defraud creditors. At 41, oh, imagine that, a timestamp, 4441.
Which was an incorrect timestamp.
Oh.
Number 9 footnote says a thumbnail image is an unmoving picture which removes a video in question. It should be noted that YouTube has a process to remove deceptive thumbnails in response to a complaint. So presumably, if the thumbnail was considered deceptive, YouTube would have already removed the thumbnail through its internal complaint process. B, Tony sold his house for $1, a single dollar. This is actual fraud, what he's doing. Tony just involved, you're right, he involved his in-laws in fraud. Tony is a fraudster through and through. Tony is a religious in and out of the courtroom frequent flyer. He's trying to avoid debt.
These statements from plaintiff's paragraph 31 will be referred to in the following paragraphs as statements A through E, respectively. As to statement A, as defendant answered above, that the statement is deliberately misquoted. Sentences are missing between other sentences, but deceptively, plaintiffs have not inserted ellipses. Oh, did I fuck that one up too?
Well, who the hell knows?
Defendant therefore denies making the statement. Defendant denies libeling plaintiff Tony Mathis by way of a statement defendant did not make. Plaintiff Tony Mathis has not submitted adequate proof the statement as quoted was ever made and therefore falls short on the basis of Crimble, which imposes a higher standard than notice pleading under the OCPA.
Nonetheless, defendant will play the ball where it lies and address the statement under the misinformation standard of New York Times. Here, defendant can concur with the statement as deceptively written. Defendant believes the statement, even
I love this. I love this. Granny, hats off to your attorney. He says, not only is it incorrect to accept this under this statute, but just in case you want to argue it at its face value, here's the other statute. And oh, I love it. I love it. Oh, I love it. I love the references. This is beautiful. This is well written. Okay, let's continue. Sorry about that.
though plaintiffs have deceptively altered the statement. Therefore, because defendant believes the statement as written, the statement cannot be actual malice, even if the statement as written had actually been made by defendant. Further, even if the statement were false, the statement would only be misinformation under New York Times standard. And if arguendo, defendant had actually made the statement instead of the statement serving as yet another example of deceptive editing in the petition.
The statements about the property deed, and in particular, the check from May 17th, 2022, attached to the C&D, did not give defendant facts to show defendant was in error about her belief of fraud by plaintiffs. Indeed, the check dated approximately 3 years prior to the dollar property transfer, and the dubious dollar property transfer itself only deepened defendant's belief the property transfer was fraudulent.
As to the statement B, the timestamp is incorrect. The quote was set at 54:12, not 53:20. Nonetheless, defendant made the statement. Defendant believed and believes the statement. Therefore, the statement cannot be actual malice because defendant believed the statement and continues to believe the statement. If the statement is incorrect, the statement would only be misinformation under.
Hats off to Granny also on that, because she is standing her ground. She's saying, look, not only did I say it, but I still think it's true. Now what? I love that. I love that. Stand on it. Oh, stand on it, girl. Good for you, Granny. Good for you.
New York Times. I do believe that statement. I mean, yeah,
I
that's
believe
my
it
full
too.
heart and belief is just that.
This is actually really well broken down, I will say. Statement B can also be categorized as half-truth under the New York Times standard. There was certainly a deed filed which stated the house was sold for $1. How can defendant be liable for defamation when plaintiff Matthews himself, an official document, claimed the consideration for the house was only $1? Even when the C&D presented the check written 3 years earlier, that does not change the fact of a quit claim.
Yeah, let's talk about that a little bit. 3 years for $1 quick claim deed? Come on. Come on, Tony. Come on. Tony. Mr. Mathis. Mr. National Spokesperson. Come on now. Are we really supposed to believe that a check written 3 years ago has anything to do with the quit claim deed you filed right before you found out that your injunction you filed against this poor woman you're harassing in Pennsylvania got slapped down, anti-slapped? What are we supposed to believe? I'm with Jess on this one. I think it's strategic.
Deed, Exhibit F, states the house was sold for $1. Under the half-truth New York Times standard, in light of Exhibit F, defendant can state and continue to state the house was sold for $1, even if the defendant gained actual knowledge otherwise. The filed quit claim deed says the house was sold for $1.
So that's a truthful statement. Statement B can be characterized as inexact under Roberts. The deed for the house says the price was $1. Under the inexact Roberts standard, in light of Exhibit F, defendant can state and continue to state the house was sold for $1, even if defendant gained actual knowledge otherwise. The filed quit claim deed says the house was sold for $1.
Statement B can be characterized as hyperbole under Roberts. There was a deed which shows the sale price as $1. Allegedly, there is more information which exists to show the purchase price was more than $1. But given the overwhelming fact of the dollar deed and the statement on the face of the deed, statement B, at the very worst, hyperbole and not libel. Under the hyperbole Roberts standard, in light of the Exhibit F, Defendant can state and continue to state the house was sold for $1, even if defendant gained actual knowledge otherwise. The filed quitclaim deed says the house was sold for $1.
As to statement C, the statement is out of context. Furthermore, note the tone of actual belief in the statement.
Granny, beautiful, you are getting that AdSense from me tonight, sweetheart. That's okay. I like supporting you, Granny.
To believe the statement. If the statement is
You're
incorrect,
right
the
on
statement would
this.
only be misinformation under New York Times standard.
As to statement D, again, the
Yes,
statement
she
was
did,
wrong.
Connie.
What
She
has
did
the
an
wrong
awesome
timestamp.
job.
Furthermore, the statement was not in reference to plaintiff's $1 property transfer, but refers to a different matter, a matter in which plaintiff admits he involved his relatives in a Ponzi scheme. Defendant believed and believes the statement. Therefore, the statement cannot be actual malice because defendant believed the statement and continues to believe the statement. If the statement is incorrect, the statement would only be misinformation under the New York Times standard.
As to statement E, defendant believed and believes the statement. Therefore, the statement cannot be actual malice because defendant believed the statement and continues to believe the statement. If it's incorrect, it was misinformation on the New York Times. See further argument below in regards to the necessity of filing an affidavit of purchase price under Oklahoma law. So this is important, okay? So in regard to necessity of filing an affidavit of purchase under Oklahoma law, defendant had and continues to have a firm and sincere basis to believe this is actual fraud, what he's doing. So now this is where Tony gets everybody awake in the chat. Let's drop some emojis. Wake up, chat. Drop some emojis. Let me know you're awake because I want you all to pay attention to what is written next.
You guys, intermission. Get your popcorn and get your tea because it's about to get good. Okay? Listen to the statute. Granny is not wrong. She's not. Okay. All right. Intermission. Everybody got their snacks and their tea? All right. Let's continue.
This is crucial. I agree, Carrie Moody. This will be a great lesson in case law for other creators, all creators, really. I hate that it's been done to Granny again, though. But I do appreciate you recognizing that. And I do have a statement from this attorney to read to you all when I'm done this. I want to make sure everybody's awake nonsense because this part is important.
Before you carry on, you have somebody in the chat that's literally looking for your attention. And
Oh, I normally don't give it to them.
I know, but they're really confused of why we're reviewing this. I don't know, because Granny's being sued.
Oh, I see. I'm going to review. First off, I've never reviewed this before. This is a brand new filing, Nimnod. This is brand new. So how many times am I going to review? Maybe I'll review it for the next entire fucking month if I want to. How about that? Maybe I'll review it until I make enough ad revenue, babies, to pay for it. Is that a good enough answer for you? Maybe I'll review it until I'm tired of reviewing it. Maybe I'll review it until people like you understand why I'm reviewing it. Perhaps that's a good answer too.
Yeah. Maybe a paragraph a day added to, a page a day added to your additional stuff just to, drive it home and the people who are trying to justify this fucking bullshit because of whatever stupidity they're on today.
Maybe I'll review it until people like you understand why this is frivolous litigation and how wrong it is. Is that a good enough answer? How about that? That's right, Liberty Farmer. And all of you, please hit that thumbs up right now and make sure that by means of thumbs up, we hit the algorithm so every creator can be prepared for little crybaby, ruffled feathers, pieces of crap that want to throw everybody into lawsuits.
They should be lucky that you are sharing with the class of what is happening to you because it could potentially help others in the future, like yourself, White Lotus.
Exactly. It can happen to any of you.
You can be here too.
They're all Nimrods. That's what a Nimrod is. If you don't like the word, make up your own. I perhaps like the fact that I made up Nimrod and my audience is aware of what the word Nimrod means. It represents Nimrods. I'm fully aware the word is shut up. We don't need to explain ourselves further. So anyway, everybody's awake now. I want to read this for you guys to actually understand this, okay? It is necessary to examine the property transfer at issue and discuss why defendant Sang had good reason to believe the property transfer was intended to shield real property assets from an anticipated Pennsylvania judgment against plaintiff Tony Mathis for lawyer fees and costs. Furthermore, that defendant had firm basis to believe this is actual fraud, what he's doing, with the $1 quick claim deed created approximately a week before an order for attorney fees and costs. It is important that everybody knows that we already had the I know it's Nimrod. I fuck around and say Nimnod because I fucked it up years ago and we just go with it. It's a running joke. I forget not everybody's aware of the running jokes. I apologize.
I fucking love that though because it's just you.
It's part of who I am, right?
It's green.
We pick it up and we keep it going.
It's Grannyisms. We all do that.
Yeah, it's literally a joke on this channel. But anyway, I
love it.
Granny's going to review all day, every day if she wants to. Amazing Blue, thank you so much. Brittany, go live. You don't need to be here watching what I'm doing. Maybe you do. Maybe you should learn a thing or two because you're next. All right. Anyway.
Sorry, I'm not broke because I'm budgeted, but
how weak the argument was. So there was no doubt in mind
Premium's
who was
not in
going
my
to win the
budget.
slap suit at that time. So again, this was a week before the judge's ruling, but after the slap court hearing. Anyway, please reference in Exhibit F, defendant concurs with plaintiffs that Oklahoma Deeds regularly recite considerations of $1 and that the deed language does not state the actual purchase price. However, please refer to 68 OS impositions of tax definitions in particular as follows. A tax is hereby imposed on each deed, instrument, or writing by which any lands, tenements, or other realty sold shall be granted, assigned, transferred, or otherwise conveyed to or vested in a purchaser or purchasers, or any other person or person by his or their direction, when a consideration or value of the interest of property conveyed, exclusive of the value of any lien or encumbersome remaining thereon at the time of sale, exceeds $100. The tax shall be prorated at the rate of 75 cents for each $500 of the consideration of any fractional part thereof, whatever. A deed may indeed be filed in Oklahoma showing a $1 good and valuable consideration, but to be in compliance with that, the purchaser of the property is expected to subsequently file an affidavit of purchase price and pay 75 cents for each 500 consideration. Do you know what Tony didn't do?
What?
He didn't file that affidavit for tax purposes.
Oh.
So my sentence of it may, I believe this to be actual fraud. Defendant saying did not know.
Uh-oh, Mr. Mathis. Mr. Mathis. Did you file a lawsuit against Granny's Watching and possibly prove that you committed fraud because of said lawsuit? Silly bear.
That 68 OS at the time she asked pinpointed non-defamatory questions about the suspicious $1 property transfer, right on the eve of a judgment against plaintiff Tony Mathis. Defendant saying simply believed the transfer was fraudulent based on the circumstances, a feeling of something smelling rotten. Defendant saying continues to believe, to this day, the property transfer was fraudulent. Taxes were not properly paid, and the transfer was an attempt to avoid the debt associated with the Pennsylvania order for attorney fees and costs.
Plaintiffs complain in paragraph 41 that a cartoon, yes, a mere cartoon, was a false allegation of fraud because the cartoon mocks the C&D. First, this is yet another example of how those who are involved in a public controversy must be men of fortitude, able to thrive in a hardy climate, per New York Times. Sensitive, thin-skinned plaintiff Tony Mathis, with his ruffled feathers and emotional distress, utterly fails to meet a New York Times man of fortitude standard. If plaintiff Tony Mathis was unable to take the heat, he should have stayed out of that hot internet kitchen where Granny's watching.
Where grannies get the joke. let's read it again. Sensitive, thin-skinned plaintiff Tony Mathis, with his ruffled feathers and emotional distress, utterly fails to meet the New York Times man of fortitude standard.
This is beautifully written. Oh my goodness. Oh, love it. Okay.
Plaintiff Tony Mathis was unable to take the heat. He should have stayed out of the hot internet kitchen where Granny's watching.
That right there, that paragraph right there needs to be just blasted everywhere.
Oh, doesn't that remind you of our good old PA attorney? Way to go, Mr. Palmer.
I was going to say, how do you find these smart asses? I love it. I'm here for it. The cartoon complained of was not created by defendant Granny, but was posted by a chat participant. Indeed, in the image copied and pasted into plaintiff's paragraph 41, shows in the upper left-hand corner a comment by the owner of the video of the Granny's Watching channels as follows. Okay, who's the author? Love them.
Because defendant is not the artist who made the cartoon, defendant is not liable for the statement's allegedly defamatory content. Defendant's comment did not endorse the statement made in the cartoon, but merely expressed love in the cartoon and inquiring who was its creator, meaning who was the author or the artist. Arguendo.
Yeah. If defendant were to be held liable for a cartoon she did not create and did not have knowledge that cartoon was going to be published in a forum open to not only fellow thinkers, but to those in disagreement, under such circumstances, it is clear the cartoon is not defamation.
The cartoon is not defamation because the word fraud is sincerely believed by defendant saying, as discussed extensively above.
A cartoon. They are saying a cartoon. Listen, this is to the extreme level. They are going to just to attack this poor woman. Okay. They are saying cartoons that they don't like are defamation. Y'all better hide your old VHS. Y'all better hide all your South Park. Can't have none of those impressions. The Simpsons, that's done. Family Guy, might as well write that one off. American Dad, kiss it goodbye. hmm Anything that's ever impersonated anyone or poked a joke at a public figure, better say goodbye to all of them. It's defamation, y'all. It's defamation, according to Mr. Mathis. What will we do?
Above. And if any of you believe that word as well, go ahead and put not a dollar, a fucking one in the chat. Speaking of dollar, I did just get your PayPal. That's what made me say dollar. Thank you so much, Feisty Nana. Put a one in the chat if you also believe that word to be true.
That you guys reading. These lawsuits blow my ever loving mind.
As discussed extensively above, a sincere belief plaintiff Tony Mathis committed fraud does not meet the New York Times actual malice standard, particularly in light of dubious $1 transfer. The lack of an affidavit of purchase in compliance with the fucking law actually implies fraud.
Well. In summary, not one statement complained of by defendant is defamation under New York Times and Roberts, which are applicable. Plaintiff's alternative argument waives allegation of actual malice.
Plaintiffs in paragraph 32 complain. Footnote 10. I don't even know where that footnote was. Defendant Sang's YouTube channel is shockingly open to those who not only disagree with defendant Sang, but insult, threaten, and even sexually harass Sang live by calling into the show or writing comments during live streams. See as recently as the show of August 24th, 2025. So that will be, I guess, an exhibit below. I didn't even realize I was there. I'm reading this with all of you. Plaintiffs in paragraph 32 complain defendant should have known her statements were false. This alternative argument by plaintiffs is an admission defendant did not know her statements were false. Therefore, do not possess actual malice.
Alternatively, defendant should have serious doubt about the truthfulness of her public statements, placing plaintiffs in a false light. By arguing this way in the alternative and arguing elsewhere in the complaint the same way, plaintiffs have argued away all their allegations of actual malice and have created an irreparable flaw in their petition. On the basis of paragraph 89 alone, plaintiff's petition should be dismissed. Further argument is below regarding frivolous and fictitious litigation.
Thank you so much, Benton. I really appreciate all of you. Sasha, thank you. We're so damn proud of our granny, and one for all, and one for all, and one for all. Hell yeah. Thank you. Sasha, thank you for the gifted. Feisty, thank you for the gifted. Angelina, you're right. Lurker, letting her lose her lackeys wait. I agree. Go start your live stream because I will not be your content today. Mark my word on that. Matter of fact, you can actually. You can. Go ahead.
Yeah, Brittany,
and
go
make me
ahead.
your content for today because you are my future litigation anyhow. So it just adds to it. But anyway, by arguing this way in the alternative and arguing elsewhere in the complaint the same way, plaintiffs have argued away all their allegation of actual malice and have created an irreparable flaw in their petition. On the basis of paragraph 89 alone, plaintiff's petition should be dismissed. You did say that already. Now we get into that they lack personal and subject matter jurisdiction. But not for just why you think, but for other reasons. In the Pennsylvania complaint, defendant is accused of being part of an enterprise engaged in racketeering activities. The complaint, which is in a state court, not a federal court, actually cites the RICO Act. In the Oklahoma petition, defendant Mathis does not complain of a RICO violation by defendant Sang.
Okay. However, accepting the outlandish premise for a moment that defendant Granny is part of a criminal enterprise in violation of RICO, then each and every one of you that of the acts complained of in the Oklahoma complaint must be also part of defendant's Granny's ongoing criminal enterprise. Plaintiff Mathis, I just realized what that says. Plaintiff Mathis complains of defamation in Pennsylvania, and he complains of defamation in Oklahoma as part of an ongoing criminal enterprise.
Right,
This is for me.
The outlandish premise for a moment that defendant is part of a criminal enterprise in violation of RICO, then each and every one of the acts complained of in the Oklahoma complaint must also be part of my ongoing criminal enterprise. Yet he only complains about me, right? So
Yeah.
Plaintiff Tony Mathis has brought a complaint against defendant Sang in Oklahoma that complains of the very type of acts alleged to be part of an ongoing criminal enterprise in Pennsylvania. The matter is on appeal in Pennsylvania. Pennsylvania has jurisdiction over any ongoing acts of defamation allegedly part of a criminal enterprise which violates RICO. Oklahoma does not have jurisdiction.
Rico Suave, baby. And we were all accused of having a hand in on it. But Granny, you know what, Granny? I'm with Granny. What exactly part of the food chain of the the RICO ladder is she on? Is she the head honcho? Is she just one of the distribution guys? Is she the guy that collects money? Is she the guy that busts knees? Where does she fit in the racketeering as well. I'm so curious. I'm so curious how it's a criminal enterprise to be a YouTube creator and have people talk in your chat. Oh no. But I can honestly say if I was Tony Mathis or anyone that was involved in filing that piece of toilet paper in Pennsylvania, they call an injunction that is going to end up people getting the floor mopped with them with their heads. People are going to end up getting the floors mopped with their heads over that lawsuit. All of them involved. I mean, y'all, this is ugly. This is really ugly. And the worst part is you have to pay attention to what's going on because this has been done because she was talking about a missing child case and spreading awareness in what was going on in his case. Some of that information came from other YouTube creators. Yeah. She was just covering a missing child's case and has been attacked like this repetitively. And I think part of the reason that she is still being gone after is because they did lose. And she is the one that told them all, go F yourselves. This is my constitutional right. I've done nothing to grieve y'all. I'm not even the one that has spoken half of these things. I've just been reporting on it when it's been reported on and given her honest to God opinion. And you know what? I mean, if you look at the law with the quick claims deed, I'm just saying, she's got a leg to stand on. Matter of fact, she's got a whole platform to stand on with both legs. Firmly planted. She has grounds to defend herself. And I hope that something is done before this harassment can continue to go any further. We talk about true crime here. Y'all want to know a true crime? This mother of two is being harassed constantly by a quote national spokesperson, constantly trying to use the forum of the court to attack her, along with other social media platforms. It's been done. She's been threatened, sent messages, the whole works. It's a crime. But this litigation affects all of us as YouTubers because this is going to set precedents. All right, let's continue. We're almost done, you guys.
In the course of their complaint against defendant Graney in Pennsylvania, the plaintiffs, to include plaintiff Tony Mathis, filed an amended emergency motion for a protective order and to enjoin unauthorized recording, broadcasting, and doxing. Emphasis added, not attached due to its volume, but described in Exhibit C. Plaintiff's motion dismissed as moot at page 3, last paragraph. In that motion, plaintiffs, to include plaintiff Tony Mathis, sought what the trial court judge described as a gag order to prohibit defendants, to include defendant Graney, from discussing a case or courtroom proceeding.
The motion is part of the active ongoing appeal in Pennsylvania, where plaintiff Tony Mathis is a plaintiff and defendant Sangs is.
Connie, that's you got me with that one, girl. Oh, sorry, I just got to read this. Connie said Tony is more like a national disaster. Oh, that's yeah, I agree with that, in my opinion. Yeah.
Defendant, and the issue is defamation. Please refer to Exhibits A through E.
They just got your goal.
Mm-hmm. Oh, we reached a goal. Thank you guys so much. I'm on the other page in La La Land. Thank you, KNS. Thank you, Choo Choo. Thank you, Up to Good. Thank you, KNS. Thank you, Choo Choo, and thank you, Peekaboo, for making the goal. I appreciate you guys so much. Thank you, and Kelly. Thank you. Thank you.
You know what they're going to do now because they always do.
I know, but I'm not.
Okay.
I appreciate it though.
All right. Are we 220? Yeah. All the matters complained about here in Oklahoma in plaintiff's petition are arguably related to the ongoing case or courtroom proceeding in Pennsylvania. The credibility of plaintiff Tony Mathis in Pennsylvania lawsuit is part and parcel of why defendant Graney was discussing the hospital lawsuit and the plaintiff's admitted non-payment of the hospital bill. Whether plaintiffs are trying to avoid the debt associated with the order in Pennsylvania order to pay attorneys' fees and costs in the ongoing Pennsylvania case is part and parcel of why defendant Graney was discussing the dubious property transfer.
It is impossible to bifurcate defendants' utterance, which are complained about in the petition here in Delaware County, Oklahoma, from the complaint in Delaware County, Pennsylvania, where an order is sought to prevent defendant from broadcasting about the case or proceeding in Pennsylvania. The Pennsylvania case is active in the appeal stage. Plaintiff Tony Mathis chose Delaware County, Pennsylvania as his forum, and now that court has jurisdiction.
Courts in other states, to include this court in Oklahoma, cannot have jurisdiction over persons of defendant Graney and plaintiff Tony Mathis because Pennsylvania has jurisdiction over an ongoing complaint between Mathis against Graney. Courts in other states cannot have jurisdiction over the subject matter of defendant Graney's past and even future utterances concerning plaintiff Tony Mathis, his credibility, and his property transfer believed related to an attempt to avoid a judgment in Pennsylvania because Pennsylvania has jurisdiction over the subject matter, to include future subject matter. Future subject matter was placed at issue by the attempt of plaintiff Tony Mathis and his fellow plaintiffs, including the famous Dog the Bounty Hunter, to impose a gag order on defendant Graney and her co-defendant Barbecue.
Yep. Kelly, thank you so much. Kiss it, BJ. And up to goes right. I'm being viciously bullied and stalked. Starts another drama live to talk trash on those creators. You are such a cry bully. You are so pitiful. You're such a disgrace. You're so embarrassing. Using all these big terms like bullied and coordination and threatened and harassed and stalked and watering down these terms for something that you actively participate in every day is exactly why you're the lolcow of this community and people milk you every day because you are exactly what you've. Oh my goodness, she's a cry bully. She's the type of person that bullies people and then when she gets a response, she fucking cries. She's a cry bully. Anyhow.
This doesn't run without the team. You can't do it all yourself. We're chasing.
And,
Me too.
by the way, it is stalking to engage in somebody's public commentary. So make sure you please hit the thumbs up and engage all you want. Please stalk Granny.
Yes, please do. And straight talkers, right? Imagine thinking you're more important than our First Amendment right to free speech. Holy shit. For better or worse, this conflict with this sprawling, at times nearly incomprehensible violence must be resolved in Delaware County, Pennsylvania, not Delaware County, Oklahoma, because Oklahoma lacks personal and subject matter jurisdiction.
Furthermore, this court lacks jurisdiction because plaintiffs are complaining of matters that are already complained of in Pennsylvania, and which cannot be bifurcated as follows.
Plaintiff Tony Mathis complains of the same set of facts in both complaints. See Exhibit A, the Pennsylvania complaint at paragraph 29, which states Seth, the biological father Sebastian, retained plaintiff Tony Mathis pro bono. Compare with paragraphs 15 and 16 of this petition, which makes the very same assertions. This is overlapping subject matter.
Can you carry on? I got to do it.
Yeah. Plaintiff Tony Mathis complains of intentional infliction of emotional distress in paragraph 229 of the Pennsylvania complaint, Exhibit A. Plaintiff Tony Mathis also complains of intentional infliction of emotional distress upon himself, individually and specifically, in a petition filed in Delaware County, Oklahoma. Plaintiff Tony Mathis makes these complaints in paragraphs 65, 102, and 105 exclusive. Unlike damage by physical assault to an arm versus a subsequent assault to a leg, the two separate assaults resulting in both limbs being broken, emotional damage to the site cannot rationally be bifurcated in this manner. Can plaintiff really take his purported emotional distress and bifurcate the portion caused by the complaint of acts from Pennsylvania complaint versus the complaint of acts in Oklahoma petition? So basically, how can Tony say which one caused worse? Like which one caused which emotional damage? How do you split it?
Emotional damage.
I know, every time I think of that meme too.
Mhm.
Emotional damage. In summary, Oklahoma lacks personal and subject matter jurisdiction. Prior to choosing Pennsylvania as his legal forum, plaintiff Mathis could have chosen Oklahoma, but plaintiff Mathis picked his forum and it was Pennsylvania. On the basis of personal and subject matter jurisdiction, the petition should be dismissed. Defendant reserves the right to brief further regarding the case law of personal and subject matter jurisdiction in support of this motion to dismiss. And then it says,
Okay, here we get back to what I was talking about whenever I was over on Trisha's, the res judicata. I knew it was going to play a role, that and estoppel. I knew it was going to play a role because of the previous lawsuit. And I wholeheartedly agree with this attorney on filing for grounds of dismissal on these claims. So
dismissal should take place on the basis of res judicata. The Superior Court of Pennsylvania Eastern District has jurisdiction. It is res judicata which court has jurisdiction. All the other matters complained of are not res judicata because all those matters are still being heard by Superior Court of Pennsylvania. But for jurisdiction alone, dismissal is appropriate on basis of res judicata. Defendant reserves the right to brief further regarding the case law of res judicata in support of this motion to dismiss. So res judicata is basically when you take the same case and you bring it into a different court, which is what they're essentially doing. Dismissal should take place on the basis of forum non-convenience. Plaintiff Tony Mathis is already suing defendant in Pennsylvania. Therefore, plaintiff Tony Mathis has already demonstrated it is convenient, not inconvenient, for him to sue defendant in Pennsylvania. Oklahoma is, however, a distant and inconvenient forum for a defendant who is a single mother with one child, still a minor, residing in Pennsylvania. Being sued in two courts at once, one of which completely lacks jurisdiction, is also, in the purely technical sense, forum nonconvenience. Dismissal should take place on the basis of forum nonconvenience, reserves the right to write a further brief, basis of frivolous and fallacious, whatever litigation.
Is it vexatious?
Vexatious, yes.
Okay.
Frivolous and vexatious.
Okay.
In Pennsylvania, the trial court judge carefully preserved in her order of dismissal, Exhibit B, the following. Indeed, at least one of the plaintiffs has stated expressly that he intended to file a lawsuit without regard to whether he would win, but solely to cause the defendants to incur fees and defendant against it. See reply in further support of true.
He sure did. He sure did. Said he was going to sue her, and he didn't care if he won or won or lost the lawsuit. He was just going to harass her. That's what it's all about. That's what it's all about. Sure did.
Motion, Exhibit A. A text message from plaintiff Mathis to defendant True stating, "Lol, I'm actually going to file a civil suit against you and make you pay to defend it. Don't even care if I win. Screw filing a C&D. Waste of time. Stand by. I was done with you, but oh well." Emphasis added. And then see my motion where Nick Hasrasu posts on a live chat replay. We're not asking for money, etc. At the end of Nonsense Monday, this could be settled by Tuesday. This is documentation in the complaint. Documentation claiming Pennsylvania is frivolous and fictitious.
Stay right there!
As such in Pennsylvania. The petition here in Oklahoma is even more frivolous and fictitious, having been filed in defiance of actual jurisdiction and forum nonconvenience argued above and estoppel argued below. Dismissal should take place on the basis of frivolous and fictitious litigation. Defendant reserves the right to brief further regarding the case law.
Okay, sorry about that.
That's okay.
Where are we at?
Dismissal should take place on the basis of estoppel.
Okay. Plaintiff Tony Mathis has filed a complaint in Pennsylvania against defendant Granny upon claims of defamation and ongoing criminal enterprise. In addition to lacking jurisdiction, plaintiff Matthews is stopped from complaining of the same matters in a petition in Delaware County, Oklahoma.
Also, plaintiff C&D was an implicit promise not to sue if certain actions were taken. Though defendant did not take all the action, such as issue an apology, defendant did issue a corrective statement about the word church, which should have been hospital, as argued above. Plaintiffs are therefore stopped from complaining of defamation over the word church versus hospital in their petition.
Plaintiff Tony Mathis is also stopped from a complaint over emotional distress due to the admission in paragraph 16. Plaintiff Tony Mathis admits he volunteered for a task that would involve emotional sacrifice, thus nullifying plaintiff Tony Mathis' claims against defendant for inter alia emotional distress. Before plaintiff Tony Mathis even knew who defendant Granny was. Hank, sorry, he sat on that.
That's okay.
He just sat right on her, and he's huge. Okay. He's such a brat. Before plaintiff Tony Mathis even knew who defendant Granny was, plaintiff Mathis claims he had volunteered for emotional sacrifice. This phrase cannot be separated from emotional distress. Oh, the please rings.
The phrase rings
of actual volunteering for such emotional distress. Plaintiff Tony Mathis is therefore stopped from a complaint over emotional distress. Hold on, let me get Hank.
Holy shit, Callie. Thank you so much. Wow, thank you. That scared you. I'm sorry. Upon any of the grounds argued above regarding estoppel, or upon any of the grounds in combination, collectively, cumulatively, dismissal should take place on grounds of estoppel. Defendant reserves the right to brief further regarding the case law of estoppel. Dismissal should take place upon the motion for summary judgment. Defendant argues above and below, plaintiffs cannot meet the high bar of the OCPA. In addition, defendants argue plaintiffs cannot meet the standard to avoid dismissal upon defendant's motion for summary judgment. Plaintiffs in their own petition prove at paragraph 4, the national spokesman, plaintiff Tony Mathis, is a public figure or limited purpose public figure, and therefore bring down the New York Times and Roberts standard upon themselves. Plaintiffs then proceed to argue matters that cannot, upon their face, overcome the standard of what speech is allowed against a public figure or limited purpose public figure, to wit, half-truth, misinformation, speech that is inexact, and hyperbole. Even without reference to OCPA, plaintiffs cannot overcome the motion for summary judgment. Defendants reserve the right to write a brief further regarding the case law.
Jess, I'm going to be on mute for a few because my kids are here and Hank is losing his mind.
Oh, I understand. No,
I'm sorry that he barked and scared you guys earlier too. I'm sorry for anybody with headphones in.
Oh, thank you, Bernie. I really appreciate you. Thank you. You guys are amazing. I really appreciate all of your support. Plaintiffs have failed to meet the criminal standard, and upon this basis, the motion to dismiss should be granted. Notice pleading does not meet the standard of Oklahoma Participation Act. Plaintiffs must make a prima facie case for all their claims under Roberts, which cites Crimble. Plaintiffs have failed to do so as follows. Plaintiffs have not proved actual malice and have actually disproved actual malice in their own pleadings, particularly paragraphs 32, 57, and 89, where defendant effectively conceded defendant
love
lacked
that
actual
part.
malice but should have known.
Cracks me up.
Plaintiffs have not made a prima facie case for the following: any and all damages, that plaintiff Tony has lost valuable contracts and accounts, that plaintiffs have suffered permanent harm to their reputations, been ridiculed, and so forth. That defendant listed other social media accounts that dox plaintiff Tony Mathis. In particular, that defendant committed defamation, libel, or slander under applicable legal standards, which are New York Times and Roberts. Prayer for relief in attorney fees and costs to defendant. Under 12 OS cited above, defendant seeks dismissal, and upon such an order of dismissal, defendant seeks court costs, reasonable attorney fees, and other expenses incurred in defending against the legal action as justice and equity may require.
Between the school chaos.
And I hope she gets awarded every penny of what she has had to spend plus. This is ridiculous, her having to do this.
Sufficient to deter the party who brought the legal action from bringing similar actions described in the Oklahoma Citizens Participation Act. Defendant anticipates a further filing documenting the court costs, reasonable attorney fees, and other expenses. Defendant seeks such other just and equitable relief as the court sees fit. Affirmative defenses: accord and satisfaction, arbitration and award, assumption of risk, contributory negligence, discharge in bankruptcy, duress, estoppel, failure of consideration, fraud, illegality, injury by fellow servant, laches, license, payment. I don't even know what all that means. Release, res judicata, statute of frauds, statute of limitations, and waiver. Respectfully submitted. And that is that.
So there you go.
Oh,
There
boy.
you have it, you guys. And again, I have posted the link in chat. It is highlighted. You guys, please go over to Granny's Watching. If you're not subbed up, subscribe, like the video, give her a shout out. Let her know you stand with her in defending against this frivolous litigation. Because again, as you can see, this all extended from people having a voice on YouTube. Now, I got something else for you guys I want to show you really quick as a palate cleanser. You guys, check this out. Check this out, okay? Look, it's sideways, I know, and I'm sorry, but check this out. This is my new Puff. This is Puff Puff. She's my new pet. She is a cavy, a guinea pig, also in the same family as like capybaras and cavies. So here we go.
Puff Puff, are you eating a grape? You hold it. Hold it. Get your back. Get your back. I love her so much.
Ah, isn't she adorable? Isn't she adorable? She is my Puff Puff, and I love her so, so much. And you guys, check it out. Now, I'm always going to continue while I can to help families in need and covering their stories and supporting victims' families on YouTube. But I'm thinking about giving Puff Puff her own little channel. I am. I'm thinking about giving her her own little channel. She is so cute. And I love her. And like, you just don't understand. She's like my everything. Okay. She's got me wrapped around her pinky already. But the grapes are round, and whenever she's trying to eat them, they roll. So yeah, now she expects me to hold them for her. It's so cute. But that's my Puff Puff, and I'm thinking about giving her her own channel. But yeah, so here's the link. I posted it. I think I can post it again. Let's see here. Yeah, here we go. Here is the link for Granny's Watching's channel. You guys, please go sub up to her. She's been talking a lot about these lawsuits, as I would too. But there's more to it. I mean, you guys, they're trying to tear this poor woman down. Okay. Do y'all really think that she has the finances as a mother with 17,000 subscribers on YouTube to pay for this frivolous litigation that is against her, trying to silence her very constitutional right, which has already been written by another judge in the lawsuit from Pennsylvania extending for all of this. She needs a little help. And the best way you can help is clicking this link right here and going and subscribing to her channel. Yep, Connie, I know you're a sub. Clicking this link right here and going to her channel and giving her a thumbs up and subscribing. Checking out her videos, catching her when she's live, maybe giving her, a shout out. I know super chats and stuff help too. But just go over there and support her. If nothing else, give her a kind word. Let her know she's not alone, that you support her, and thank her for what she's doing. Because without Granny sharing this traumatic experience that she's going through in this frivolous litigation, uh, I don't think that people would be aware of what can exactly happen to them, that they themselves might someday having to be fighting in a court of law. So I think it's just very important to educate ourselves with this. And I think Granny is doing such a marvelous job of fighting. She's standing on what she says, or she's defending the blatant lies and the way the words are twisted in the new frivolous litigation with that Tony Mathis has filed against her. So go over there and give her a like and subscribe. It is 12:33. I planned on being done at 11. So we've gone an hour and a half past that. This might be my longest stream yet. I don't know. But so I am going to go ahead and get off of here. I'm glad we did get it covered though. Because like I said, this is very important to all of us YouTubers. And I do think it is absolutely a crime what they are putting her through. And I think that it's terrible they're using the court systems to do it. And I think everyone should be made aware of it, what's going on. So with that said, you guys, remember, I'm sorry. I was reading Connie's. This is, yes. Yes, I agree, Connie. This needs to stop. She did absolutely nothing wrong. Yep, it's past my bedtime too. So, as I was saying, with that said, you guys, share a smile and save a life. Remember, the life you save might even just be your own. Kindness is free and hate costs us so much. Share a little love in the world. Lock your windows and doors and be safe out there, because it is crazy in this world. And with that said, you guys, I'm going to bed. Blessings and good night. And thank you for being here. Bye.